Morning, Judge.
You're muted, Your Honor.
Good morning, everyone. This is the state all-purpose calendar. Are we ready to begin?
Good morning, Your Honor.
Good morning. Our defense attorneys present at courtroom 2. Good morning. All right. I'm assuming we need a few moments there, and we'll get started shortly.
You're muted. Good, I'm glad they didn't hear that.
Was there someone saying something at courtroom 2?
I still muted. Still muted.
You're unmuted. We can hear you.
Okay, thank you.
It seems like maybe they can't hear us.
Hmm.
We can hear you.
We're wondering.
We can hear you. Yes, Your
Oh,
Honor.
okay, great.
Did you?
Yeah.
Are we ready to start, Your Honor, or?
We are ready to start. I was waiting for an announcement at courtroom 2. Have all our defense attorneys prepared to begin?
Yes. Yes, Your Honor.
Okay.
Yeah.
We're always ready, Judge.
All right, wonderful. Can you all hear me at courtroom 2? I'm going to explain the rights. Good morning, everyone. This is the state all-purpose calendar in the state court of Fulton County, Georgia. I'm Judge Melanie Williams, and today is August the 13th of 2024. At this calendar today, we'll address a variety of matters, including taking pleas, arraigning cases, and addressing bond as necessary. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. As you can see, I'm conducting this hearing over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch. When I ask if you understand your rights, that is what I am referring to. All right, who do we have first? And I've all defense attorneys had the opportunity to interview their clients.
Yes, Your Honor.
Except for, we do have one that requires a translator, Judge.
All right, will we have translation today, Mr. Jordan? Well, I can't hear you.
We're confirming, Judge.
You're working on that? Okay,
Yes,
thank
ma'am.
you. All right, who do we have first?
We can start with position number one, Mr. Anthony David.
Let me pull up the announcements. All right, good morning, Mr. David. Your case is 24 CR 005204F. In this case, you are charged with simple battery family violence with the offense date of July the 27th. Do you understand your rights today?
Yes, ma'am.
All right, and I have that this is gonna be a waiver of arraignment, not guilty.
Yes, Your Honor, with a bond argument.
Okay, and will you enter that formal waiver today, Mrs. Ty?
Yes, I will.
All right, I'm ready to proceed with the bond arguments. Before we begin, Ms. Tyson, can I have this defendant's history, please?
Good morning, Judge.
Morning, good to see you.
You too. We have 5 arrest cycles beginning in 2019. We have a felony case out of Fulton County for aggravated assault. He received first offender treatment on that case, March 2nd of 2023. He received 2 years, 4 months probation on that case. And it looks like he has a pending case out of Clayton County for driving while license suspended or revoked. Disposition states warrant was issued March 7th of 2024. And he also has an open felony case in Fulton County with the arrest date of December 22nd, 2023 for battery, family violence in the first degree and cruelty to children in the second degree. That case number is 23 CP 224361.
Thank you. All
And
right.
one FTA, I'm sorry, and one FTA out of Clayton County with the arrest date of June 10th of 2024. That was his last arrest.
Okay, so this past summer, okay. thank
Yes.
you. All right, Ms. Falk, please proceed.
Yes, Your Honor. I do just want to point out before we get started, the victim in the 22 SC case where he's currently on first offender probation is the same victim as in our case, which is also the same victim in the 23 CP case that was read off to you by pretrial services. On that new case, he's being held, well, he was held on a $25,000 surety bond with a order that he have no further contact with our victim. So in fact, he was already in violation of his felony bond when he had contact with the victim in this case. This incident happened June 27th of 2024. The officers were called out to 2070 Allison Court Southwest to a physical disturbance. It stated the female caller said the male suspect stated he was going to kill her and she ran away to the store and was hiding in the restroom. Once they got there, they met with McKenna Clark, who stated the defendant had hit her in the face. She also stated she was in fear for her safety and it was not going back to the residence. They then, earlier that day, they did receive a call previously from that residence and responded. And she stated she had been in a verbal dispute with the defendant because he wanted more money from her so he could buy drugs, and that they asked him to leave and then he came back to that location. The recommendation on this case, Your Honor, is that the bond remain as set. It's currently set at a $2,000 surety bond, which given the fact that he's on probation for an incident involving her where he was ordered to have no further violent contact, and then he also has a current bond with no further contact, I believe is quite low considering the circumstances. We did speak with the victim about the plea recommendation. She was in agreement with it. She also wanted him to have some sort of alcohol drug evaluation and treatment. So that is what we are asking. We would like to sound at this time for McKenna Clark.
Ms. Clark, if you are present on the Zoom conference, wish to make a statement, please turn on your camera and raise your right hand so I can place you under oath. You are not required to make a statement, however.
Okay, my screen is broken, but I'm right here.
All right, please raise your right hand. Do you swear and affirm the testimony you give today to be the truth to the best of your knowledge?
Yes.
All right, what would you like to tell me?
Okay, so that day we've been going through it. Like you said, it was the multiple cycles, right? But it was none of that. The police never comes when you call them. So more so you have to say things that aren't true to get them to come. He has been having this little habit that he needs help with that nobody has been giving him help with. He's just been getting locked up and, stuff like that. He shows up for his son every chance we get. So those violations and court orders he's been getting, we have a child. He does everything for his child. I work. He was working before all this happened, but it's just a little drug incident that he had. But all that other stuff that the police got going on, first of all, they misheard me. I said, could y'all hurry up? What if something was to happen to somebody and somebody end up dead or killed, is what I said. But they was like, we understand that, but there's nothing we can do about that. And that's when I hung up the phone. And so just to explain that part, but yeah, I'm in favor of him getting out and everything. It was never no whatever all that they're saying. It was more so to get the police to come because he needs help. Maybe that was wrong on my part. I don't want to be around nobody that's doing drugs. I don't do drugs. So the fact that I know you need help, I'm gonna try to get you the help as best that I can because we have a child. You are a good person, but I don't want that around me. Like, I don't know. That's really all I had to say. Like, I just didn't want that around me, so I did what I felt was best. And if that was to call the police to tell them to please come get him, so he can detox and clear his mind a little bit, then that's what I did. And that's all I had to say.
Thank you, Ms. Clark. I appreciate you making that statement. Ms. Atai, please proceed.
Yes, Your Honor. I spoke with the complaining witness, and as you heard her just say, she made statements to get the police to come out. She told me that he never touched her. In light of that, Your Honor, he does have 4 minor children, a 2-year-old, a 3-year-old, a 6-year-old, and an 11-year-old. He was working in landscaping. He, of course, denies the allegations as stated in the warrant. And as you heard from the complaining witness, nothing happened. She made statements to get the police to come out. So I would ask for the surety bond to be converted to a signature bond through pretrial services. Even if it's at level 3, he has been in custody for 17 days when nothing happened, according to the complaining witness.
And Your Honor, I would disagree that nothing happened. He violated the conditions of his previous bond under 23 CP that he have no contact with her and stay away from Allison Court. So something did in fact happen. He violated his previous bond condition.
He's charged with a
All right.
simple
All
family
right.
bond.
All right, bond will remain as set with the same conditions. Best of luck to you, Mr. Anthony. All right, who do we have next?
We can go to position 3 and 4, Mr. Barbara Davis.
Okay, so 3 is the FTA. Oh, I have that as 2 and 3. Is that not correct?
Yes, 2 and 3.
Okay, so is he coming forward?
Yes, yes, Your Honor.
Thank you. All right. I have that this is the negotiated plea. Is that still the announcement?
Yes, Your Honor.
All right. All right, good morning, Mr. Barber. Your case is 23 CR 003358J. You're here for a dog at large charge with the offense date of January the 15th of 2022. You also have an FTA. The announcement is that this is a negotiated plea, so I'm going to go ahead and place you under oath. Can you please raise your right hand? Do you swear and affirm the testimony you give today be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, thank you. You can put your hand down. Ms. Falk, please proceed.
Yes, Your Honor. The state's recommendation in this case is time served. At this point, I believe the defendant has served 9 days in custody against, and so we're asking for 18 days with 9 to serve. This happened back in January 15th of 2022. The defendant had a dog off leash and it was cited for dog at large. And we would ask the defense stipulate to venue, factual basis, and identification for the purposes of the plea. We are null crossing position 3, which is the FTA.
Now, is your understanding, Mr. Ty, do you so stipulate?
Yes.
All right, I'm going to ask you some questions, Mr. Barber, reminding you under oath to make sure that you are taking this plea voluntarily, okay? Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone promise you anything in exchange for taking the plea?
No.
Did anyone force you to take the plea?
No.
And are you satisfied with your attorney's representation?
Yes.
And you understand that taking the plea, you're giving up your right to trial by judge or by jury?
Yes.
And you further understand that taking a guilty plea may affect other aspects of your life that I can't anticipate, such as probation, immigration, or other things that your attorney may not have thought of either?
Yes.
All right, as to the charge of dog at large, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Falk or Mr. Ty?
Nothing from the state.
All right, best of luck to you, sir.
Thank you.
Well,
Next, we can go to position number 10 and 11, Mr. Benton, Octavius Benton.
10 and 11. Okay. Is it Quintavious Benton?
Yes.
Okay. All right, good morning, Mr. Benton. Your case is 24 CR 004940G. In this case, you're charged with simple battery with the offense date of July the 17th of 2024. You also have 24 CR 005329G, in which you're charged with obstruction, trespass, simple battery against an officer, and failure to use a crosswalk. Do you understand your rights today?
Yes.
Was that? All right, thank you. And the announcement I have for this is that this is going to be a non-negotiated plea.
Yes, Your Honor. It's a time served offer, but just about the conditions.
Okay. All right, since it's non-negotiated, can I have the history, please? Ms. Tyson.
Yes, we have 16 arrest cycles beginning in 2013. His last arrest was July 30th of 2024 in Fulton County for willful obstruction of law enforcement officer, interference with government property, and simple battery against a police officer. Let's see, it looks like that's position 11.
Oh, that was 11. Okay.
That's 11, yeah, okay. See, he has a failure to appear. Out of DeKalb County from June 13th of 2024. And it looks like he has a pending case for criminal trespass, willful obstruction of law enforcement officer. No dispositions listed for that case. And it looks like he has a December 2023 arrest out of DeKalb County for simple battery. No dispositions listed for that case either. Let's see. He has a misdemeanor conviction out of DeKalb County for criminal trespass from May 2nd of 2023. He has another misdemeanor conviction out of DeKalb County from March of 2023 for criminal trespass and willful obstruction of law enforcement officer. He has another criminal trespass out of DeKalb County from August of 2022. He has a, let's see, misdemeanor conviction out of Fayette County for DUI. Looks like 2 counts. I'm sorry, 3 counts. That's out of Fayette County from August 7th of 2023. And he looks like he got 12 months probation, 40 hours community service hours, and a $1,000 fine on that case. He has another criminal trespass out of DeKalb County from June of 2022, which he took a NOLO plea on. Let's see, nothing to add, Your Honor.
Thank you. Before we get to Ms. Falk, I see Ms. Chancey is on the line. Mr. Ty, do you represent the gentleman who needs interpretation?
No, Your Honor. Tom White does.
Okay, so is it possible for that person to be moved to a courtroom with Mr. White so Ms. Chancey can help with the interviews? Or will we have to wait for that?
where is he?
We're gonna have to wait
He's
for
on
that, Your Honor.
visit.
He's not in courtroom too.
Okay, so whenever that person is moved, please let me know so we can put Ms. Chancey in there. All right. All right, Ms. Falk, please proceed.
Yes, Your Honor. It looks like the defendant took a plea to all of the cases in DeKalb County on, I'm trying to look at the date, July 10th of 2024. I went to the DeKalb County website and looked through all of the cases. They are all now
Oh,
closed with negotiated pleas as to all of them. And he pled in exchange for just a straight confinement plea, it looks like. I'm not seeing any, and I'm just taking another look. I'm not seeing any additional probation stipulations. Well, I take it back. So there is a 12-month on the criminal trespass. There was a 12-month do not return to advanced auto tech in Decatur. So he is on probation on that case. That's going to be 23-02-307 out of DeKalb County. He also had that criminal trespass and obstruction of law enforcement officer. He did receive all fines suspended and case closed. So most of those cases in DeKalb County, all of the cases are closed. Most of them, he just received a straight time served sentence with the exception of one, which did include a stay away order. One also included an undergo alcohol and drug treatment as directed by the probation office, and that the case be closed once all the conditions were met. That was 22C-03079. So I just wanted to point that out to show that he has actually multiple cases that he entered a plea on July 10th out of DeKalb County. So all those cases that show open are actually closed, and he pled guilty on all except for one, which was a NOLO. In this particular case, Your Honor, the state is asking for 12 weeks anger management, 40 hours community service, as well as no firearms. Additionally, we're asking for MHET. These sentences run concurrent, so whatever he completes as to one sentence will be deemed to have met the conditions of the other sentence. The reason for that is because of his history. This incident happened on July 17th, 2024. I want you to note that, Your Honor, because that was 7 days after he was released on all of his cases out of DeKalb County. So on July 17th, 2024, a Georgia State University student reported being spat on by the defendant to the responding officer. The victim, Adetoye Allen, stated that the defendant attempted to stop her while she was walking past the Pizza Hut on Piedmont Avenue. When she refused to stop walking, he spat in her face while being approximately 3 feet away from her. The officers did get surveillance footage and were able to identify her as well as the defendant in that footage. And then showed her immediately reacting, turning around and staring at him as he walked away from her, headed northbound on Piedmont Avenue. The defendant was then arrested for simple battery on that case. And when the officers spoke to a witness, they stated that the witness stated, Miss Adetoye Allen stated she wants to press charges due to him staring at her multiple times through the workplace's glass windows where she worked. She also stated that she had to tell him to leave the store multiple times. That was on July 19th when she did state that, yes, she wanted to press charges due to his behavior. 10 days later, the defendant was taken into custody by the officers. He struck Officer Augustin in the mouth with the back of his head while he was being placed in handcuffs. When he was placed in the vehicle, he began kicking the vehicle repeatedly, which bent and damaged the patrol door of the vehicle, as well as, let me just see, there was one more charge in here that we just need to cover, as well as actively resisting arrest from the officer, and was walking. And what led to the arrest in this case was he was walking in and out of traffic. And the officer advised him to stop walking in and out of traffic due to the danger that presented to the people on the road as well as himself. He refused, and that's when the officer took him into custody. So clearly there are some issues here, Your Honor. He literally 10 days after he was sentenced on a litany of cases in DeKalb County, then comes to Fulton and literally picks up where he left off. That's why the state was asking for an MHET, 12 weeks of anger management, and 40 hours of community service. So we do ask that those conditions remain in place. The rest of the plea, Your Honor, is on the simple battery, 12 months served, 40 days, credit for time served, 20 days. No further contact with Miss Adeote Allen. Stay away from the Pizza Hut at 25 Piedmont Avenue. And on the second case, we asked for time served as to all counts except for the simple battery, where we were asking for 12 months served, 32 days, credit for time served, 16 days, balance probated, no further violent contact with law enforcement, 12 weeks anger management, 40 hours community service, and no firearms. We would like to ask the defense to stipulate to venue factual basis and identification for the purposes of the plea, and we would like to sound from Ms. Adeote Allen.
All right, is Ms. Adeote Allen present? Wishes to make a statement before I hear from Ms. Atai? All right, hearing and seeing none. Ms. Atai, your response and request of the court at this time is?
Yes, Your Honor, we do stipulate, he is entering a guilty plea today, and I have no objection to, the stay away and in position 10, and, no further violent contact on position 11. He can, have an MHET done. I believe that he can get that done for free at Grady. I'm not sure. But he has been homeless he's 25 years old. He has lived in Georgia all his life. He does have an address where he receives mail and his disability check. He does have MH issues, Your Honor. His mother is the payee on his disability check. It's about $700 a month. He's been homeless for 3 years. He doesn't have a phone and he doesn't have a home. He has no income. So I'm just asking to waive objecting to the 12-week anger management and the community service and the $300 fine.
I'm thinking, I think some measures are appropriate here, Ms. Atai.
Yes, Your Honor, I'm asking for, the probation until he has the MHET done, that he's on probation. And of course, I'm going to ask for the probation fees to be waived. He has no income, and it is in Your Honor's discretion to waive any fees.
Right, I get that part, but I mean, to say we're gonna do absolutely nothing upon release, I'm asking for any counter suggestion. I mean, I understand we're all in agreement on that MHET, but beyond that, you don't think any other measures your client will be able to get done at all?
I don't know what measures somebody who has MH issues and has been homeless for 3 years. I don't know what.
Okay.
I mean, he's not in a position to.
Right, I know, hold on, I wanna look one thing up really quickly. Ms. Tyson, I'm sending you a chat very quickly.
Okay.
Let's see. If I can find you to send it. Maybe I need to ask probation. And who's here from probation today? Anyone?
It's A. Tyson, pretrial judge is what it says. And then
But
check.
that's pre-trial. Anybody from probation?
Oh, probation, I'm sorry.
No, it's okay. Anybody?
No, it's nobody from probation on.
Nobody from probation? Okay. What I'm trying to figure out, are there any free or low-cost classes that your client could engage in, Mr. Ty? That might be, I do understand your position, but I also understand the state's position as well. So I was trying to think of a dynamic solution that maybe all parties could agree to if there was no cost involved to Mr. Benton, but no one is here from probation at this time. All right. Against my better judgment, if the defendant Okay, that's a good suggestion. One more second. Give me
Hello, excuse me, sorry, Judge, Your Honor. Miss
Good
Thomas stepped out for a minute.
Good morning. My question was, are there any free or low-cost equivalents that probation offers that might be an option for this defendant?
May you say that one more time, Your Honor?
I said I'm trying to figure out, are there any free or low-cost classes that defendant could take that might be an option or an alternative to anger management?
Yes, there is. There is a list that we can send to the attorney, his attorney, of
Okay.
some classes.
Okay, so what I would like to, I'd like us to revisit this in a moment and let Mr. Ty take a look at that class and make me a suggestion, because what I'm gonna do is, if we can't come up with some measures through probation he can take, I would accept the state's recommendation, okay? So can we send that over to Mr. Ty at this time?
Yes.
Okay,
One moment.
let's recall this case in a moment and let's move forward and give Mr. Ty a moment to look at those.
Thank you, Your Honor.
All right.
Third row, sir. Third row. I am. Next, we can go to position number 22, Mr. Dominique Gay.
Okay. Okay. Good afternoon. Oh, it's not afternoon. It's still morning. Good morning. Been a long morning already. Your case, Mr. Gay, is 24 CR 005311Y. You are charged with obstruction and trespass with the offense date of July the 27th. Do you understand your rights today?
Yes, ma'am.
All right. And what is our announcement for this case?
Negotiated plea, Judge.
All right. Thank you. Ms. Falk, proceed.
Yes, Your Honor. Which number is this?
22, Mr. Gay.
22. Okay. And Your Honor, just to make sure, because I apologize, I know we've had different judges in front of us. Do you want me to go over the factual pattern before I
like a brief factual basis. You've been doing good.
I understand the emphasis on the word brief. All right. So
Not when
the
we
state-
start with the time that the person was called out. Let's not do that. But you've been doing
the state's recommendation is to count one as time served. That's going to be 36 days, credit for time served 18 days, which will release him. And criminal trespass is going to be 12 months served 36 days, credit for time served 18 days. Balance probated, stay away from the Texaco at 2067 Delow Drive in East Point, 40 hours community service. We're also asking for a social worker visit prior to release. That's because the defendant has 2 prior convictions, which I've listed on the sentence recommendation sheet with that same location. And on both occasions, he was given 12 months suspended and he keeps going back to that location. So we're hopeful maybe if there's a social worker visit, we can get him some help. So on this particular occasion on July 27th, the defendant went into the location at 2067 Delow Drive at 3:26 a.m. He was making verbal threats to customers, and he had previously been given a warning at 2:45 a.m. by the officers and the store clerk to leave, but failed to do so, which led to his arrest. The state would ask the defense to stipulate to venue factual basis and identification for the purposes of the plea.
Stipulate, Your Honor.
And that was your understanding of the offer?
It is, Judge. As for the social worker issue, we'll have a social worker meet with it. But as a condition of probation, that doesn't really make any sense because it's prior to his release and probation can't enforce that.
Well, what will happen is if it goes on the order, he's not going to get out of jail till the social worker comes. So it's not a condition of probation. It'll be a condition of release from Fulton County Jail. So are you objecting to that at this point?
Judge, I would object to that. I'm not sure that the social workers can help them while they're in jail. There's not a lot that they can do for them when they're out. So the way our office works, it's completely voluntary, anything that they would have for them anyway. So it seems a bit unhelpful at any rate.
Okay. All right. Well, I won't require the social worker visit prior to the release. Let me just double check. Go ahead. I'm sorry.
We'll still try to have someone speak with him to see if there's anything they can do for him, but
We won't make it a condition of his release.
Thank you.
All right, Mr. Gay, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right. Are you under the influence? You can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force or coerce you to take this plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand that you're giving up your right to trial by judge or jury?
Yes.
Are you satisfied with your attorney's representation?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life, such as probation, employment, immigration, things of that nature?
Yes, ma'am.
All right, as to the charge, and you further understand that you cannot go back to that Texaco and you are to complete the 40 hours of community service?
Yes, ma'am.
All right, as to the charges I previously listed, Mr. Gay, how do you plead?
What?
How do you plead?
Guilty.
All right, I accept your guilty plea. Is there anything additional, Ms. Falk or Mr. White?
Judge,
Nothing from the state.
if you waive 2 months of probation fees, give him a chance to, that should be plenty of time to get 40 hours of community service done, but he doesn't have any income at this point, so.
All right, I will waive 2 months.
Thank you, Judge.
All right, take care.
You got to see that.
Sounds good.
Yeah.
Next, we can go to position number 23 and 24, Mr. David Gilman.
All right, 23 is the FTA, correct? So Mr. Gilman, oh, he's coming. Mr. Gilman, your case is 22 CR 0099, I'm sorry, 00998F. In this case, you're charged with giving false information. You're also here for an FTA. Do you understand your rights?
Yes, I do.
All right, let's see. And the announcement I have is negotiated plea, is that correct?
That's correct, Your Honor.
All right, Ms. Falk, please proceed.
Yes, Your Honor. This incident happened back on, let's see, trying to find the date of the incident itself. It looks like this happened March 31st of 2020. The officers noticed the accused on a bicycle with no light. They asked him his name. He gave the false name and date of birth, Stephen Gilman, date of birth 6/17/1965. The state's recommendation is a time served recommendation, 48 days, credit for time served, 24 days. And I put the dates from 7/31 to 8/1 of 2022, 12/27 of 2023 to January 6, 2024, and then August 3rd of 2024 to today. We will also agree to null pros the FTA. We would like the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Stipulate, Your Honor.
All right, thank you, Mr. White. Mr. Gilman, please raise your right hand. Do you swear and affirm testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
I do.
All right, you can put your hand down. All right. Are you under the influence of any drugs or alcohol at this time?
No, I am not.
And are you satisfied with your attorney's representation?
Yes, I am.
Did anyone force you to take a plea today?
No, they have not.
Did anyone promise you anything in exchange for taking a plea?
No, they have not.
And you understand that by taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes, I do.
And you're giving up your right to have the state prove this charge against you beyond a reasonable doubt.
When I say yes,
You're giving up the right to have the state prove this charge against you.
yes, I do.
All right. And you know that taking a guilty plea may affect other aspects of your life?
Yes, I do.
All right. As to the charge of giving false information, Mr. Gilman, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional? All right.
Bench.
Anything from the state, Ms. Falk?
No, Your Honor.
All right. Best of luck to you, Mr. Gilman. That concludes your case.
That was that wrong.
Thank you.
Next, we will go to position number 40, Mr. Christopher Smith. You can, sir, this way.
All right. Good afternoon, it's still morning. Come on, Melanie. All right. Good morning, Mr. Smith. Your case is 23 CR 002685J. You're charged with battery, family violence, and simple battery, family violence with the offense date of February 15th of 2023, actually. You understand your rights?
Yes, I do.
All right. This is a negotiated plea. Is that correct?
That's correct, John.
All right. Ms. Falk, please proceed.
Yes, Your Honor. This incident happened back on February 15th of 2023. Officers responded to 1033 Hollywood Road, where they spoke to Terry Smith, who stated she and her son were in a verbal altercation. She stated the defendant had come to the above location without her permission, and he was putting something in the microwave that started to overflow. She asked him to go check on it. He got upset, called her a bitch, stated he was going to beat her ass. And then she asked him to leave. He refused. He turned around and then punched her in the face. She had a visible light red mark under her eye, which was tender to the touch. The also stated that he does not permanently reside at that location, but often visits when his twin brother lets him in. The state's recommendation on this case, Your Honor, is 12 months, serve 82 days, credit for time served, 41 days. That's going to be from April 29th to May 6, 2023, and then from July 12th to today. Balance probated, FVIP, 40 hours community service, no further contact with Terry Smith. Stay away from 1033 Hollywood Road in Atlanta, no firearms. Count 2 would merge with count 1. We would like to sound for Terry Smith, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
You so stipulate?
We'll stipulate, Your Honor.
All right. Mrs. Smith, please raise your right hand. I'm going to place you under oath. Do you swear and affirm testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, I do.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, I'm not.
Did anyone force you to take a plea today?
No, I didn't.
Did anyone promise you anything in exchange for taking a plea?
I did not.
And you understand taking the plea, you're giving up your right to trial by judge or jury? Is that a yes?
Yes, that is a yes.
All right. And you further understand the requirements that you can't have any contact with Ms. Smith. You'll need to stay away from Hollywood Road address. You're going to do 40 hours of community service and take a course. You understand all of that, Mrs. Smith?
Yes, ma'am, I understand.
And I just want to clarify, you are satisfied with Mr. White's representation today?
Yes, I am.
And you understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, immigration, anything of that nature?
Of course.
All right. As to the charge of battery family violence, how do you plead? I accept your guilty plea. Is there anything additional, Mr. White or Ms. Falk?
There's nothing further, Judge.
No, Your Honor.
All right. Best of luck to you, Mrs. Smith. That concludes your case at this time. Oh, I see ACDC has logged in. They did not. Did ACDC hear their rights?
No, Judge. Good morning. They did not.
All right. Good morning. Let's do that quickly. Good morning, everyone. I'm Judge Melanie Williams. Today is August the 13th of 2024, and this is the State All-Purpose Calendar. At this calendar today, we will address a variety of matters, including taking pleas and arraigning cases and setting bonds as necessary. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. As you can see, I'm conducting the hearing over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this. I want to ask if you understand your rights. That is what I am referring to. All right, who we have next?
This is going to be number positions 4, 5, and 6. Bates, Bridget Bates.
All right, Ms. Bates, good morning. Your case is 23 CR 008256B. You're charged with unlawful conduct during a 911 call back in January of 2022. And your other case is 24 CR 005408B. In that case, you're charged with battery, family violence, first offense, with the offense date of August the 1st. Do you understand those rights I just explained?
Yes, ma'am.
All right, I have that this is a negotiated plea, is that correct?
Yes.
Not you, Miss.
Yes,
Miss
this is Gregory Murray.
All
Her
right.
husband.
Oh, wait, no. Who represents Miss Bates? Is it you, Miss McLeod?
That would be Mr. Ty's case.
Oh, Mr. Ty, is Mr. Ty there?
Yes, she stepped
He
away.
was here a moment ago.
Yes, sorry, Your Honor. I didn't
That's
know.
okay. That's all right. This is, we're confirming this is still a negotiated plea.
Your Honor, it's a non-negotiated plea.
Okay. And at issue is the jail time, I'm assuming?
Well, Your Honor, she and the complaining witness is here for position 5, that battery family violence case. She doesn't want to plead guilty to that. She will plead guilty to position 4, unlawful conduct during 911 call, and I would object to the ADET in that case.
Okay, so let me clarify. I'm confused. So we're taking a negotiated plea as to position 4, and position 5, we're doing what?
She's pleading not guilty, waiver.
Oh, and we're arraignment. Are we being heard on bond for position 5?
She has a signature bond on position 5. I
Oh.
believe the complaining witness was there at first appearance and stated that nothing happened.
Okay. All right. Ms. Falk, let's proceed on position 4 then.
Well, Your Honor, this is a global recommendation.
Okay, so basically we're gonna be pleaded not guilty for both of those then, Mr. Ty?
Well, Your Honor, she is held on the FTA for position 4. So she's stuck in jail, as you know. So she's
Well,
been here.
4 is not an FTA, 4 is the actual case.
But
So,
that's the case where she has the FTA with the bond that is holding her in jail.
okay,
and
so the question is, do you want to be heard on bond then? For
Um,
position, is that the state is not willing at this time to give her, to let her take a plea to position 4 without taking a plea as to position 5.
But Your Honor, you can allow her to take a plea to position 4, unlawful conduct during a 911 call. She has been held for 13 days and she is wanting to plead guilty to that.
Well, that is true. I guess I could do that. And we could take it as a non-negotiated, but the state in light of that offer, would your offer change at this point from what's on the calendar, Ms. Falk? What's the offer then?
Yes, Your Honor. If you'll give me just a moment, because I now need to look at review her history in making my
Okay.
new offer.
Let's ask Ms. Tyson. Ms. Tyson, what is the history for Ms. Bates, please?
She has, let's see, 6 arrest cycles beginning in 1989. She has a misdemeanor conviction outside the 10-year period for simple assault. That's from 2008. Her last arrest, let's see, is that's position number 4 out of East Point. Let's see, it appears she has no felony convictions, Your Honor. Nothing to add.
And Your Honor, in this particular case, on January 19th of 2022, officers were dispatched to 3072 Washington Road, apartment I-2. They spoke with Miss Bates, who stated that she and her live-in boyfriend, Mr. Gregory Murray, who is, just make sure before I say this, who is the same person in position 5, the family violence battery. They were arguing and he wouldn't leave. She was visibly intoxicated, slurring her speech, stated she wanted him gone. He was in the back bedroom asleep. She had been told previously several times how to get him out of the residence that he lives in. She had essentially called 911 4 times with no emergency, hung up before the dispatchers could talk to her, and was highly intoxicated when she was called and was transferred from the Fulton County dispatchers. And so finally, after the 5th call, and her continuing to call and hang up, they came over to the residence and arrested her and took her to East Point Jail for unlawful use of 911 emergency services. The state is willing to leave the jail time in place. However, we do insist upon the ADET, given the fact that she was, according to the officers, highly intoxicated when she reached out to them on this particular date, and was constantly calling 911, asking for services. I also believe, and let me just double check something really quickly. Yeah, she also acknowledged in her subsequent case, which, I'm going to bring up because it's part of a global resolution initially, that they had alcoholic beverages the morning of that incident at approximately 6:30, and she had gone to go get more alcoholic drinks. The fact that, you've got her own admission that she's drinking at 6:30 in the morning, that she had several alcoholic drinks already, coupled with the fact in this case that she was visibly intoxicated, I think there is a clear need here for ADET services, or at least an evaluation to see if there's a need for treatment.
Okay. Ms. Atai, any response?
Yes. She has lived in Georgia all her life. She does work full-time at UPS as a package handler. I do not think that the charge here, unlawful conduct during a 911 call, supports an ADET. She does not state that she has a drinking problem. Drinking in your own home, whether it's at 6 a.m. or noon or 9 p.m. She is pleading guilty to the unlawful conduct during a 911 call. She called 911 4 times. She's pleading guilty to that, and I would just ask for it to be a time served sentence. She has served 13 days. I don't think that she needs to be on probation for calling 911 4 times or do an ADET. So I would just ask, Your Honor, for a time served in this case. She does have a job to get back to, and I don't think that she needs to report to probation for, I think, 11 and a half more months for that.
All right, if she takes the plea today, I am going to require the ADET and that she's on probation. Does she still want to take the plea today?
Your Honor, once she completes, I don't know. It's a 911 call.
I understand all of that. So the question is, does she want to do it?
Yes, Your Honor, but can I ask for probation fees to be waived and probation to be non-reporting once she completes the ADET?
I will, once she completes the ADET, it can go non-reporting, and I'm only going to waive 1 month of fees. So, because it shouldn't take her long to get that done. All right. So your client does want to take the plea today to position 4?
Yes, she does, Your Honor.
All right. All right, Ms. Bates, please raise your right hand. Do you swear and affirm the testimony you give today be the truth to the best of your knowledge? Penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time? Is that a no?
No.
Okay. Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking the plea?
No.
And are you satisfied with your attorney's representation?
Yes.
And you understand the requirements of the sentence, that you are going to have to undergo an evaluation?
Yes.
And you understand that you're giving up your right to trial by judge or by jury?
Yes.
And do you further understand that taking a guilty plea may affect employment, probation, immigration, any open cases, and other things your attorney or I may not be able to anticipate. Do you understand that, Ms. Bates?
Yes.
All right. As to the charge of unlawful conduct during 911, how do you plead?
Guilty.
I accept your guilty plea at this time. The other case will be reset for the notice. Is there anything additional, Mr. Ty or Ms. Falk?
Nothing from the state.
Nothing further, Your Honor.
All right. Best of luck to you, Ms. Bates. Have a good afternoon.
Okay,
Who do we-
thank you. I'm sorry, I just wanted to confirm, so on the record, position number 6 is Norcross, correct?
That is
No.
correct. I'm sending
Oh,
over.
yeah, yeah.
Thank
Yes,
you.
that's the case she took the plea on, so I am sending the paperwork over.
I thought it was 5 for a second. I said, no, we didn't know from something. All right. All right, who do we have next?
Next judge is gonna be number 12, Bowden.
Wow. All right, good morning, Ms. Bowden. Your case is 23 CR 001291F. You're charged with simple battery and theft by taking. Do you understand your rights today?
Yes, ma'am.
All right, and I have that this one is negotiated. Is that correct, Ms. Atai? Maybe I'm looking at it wrong.
Oh, sorry, Your Honor, I need a minute.
That's okay. Looking at the grid, it says, no, it says this is a conflict. Is this yours, Miss?
Oh,
Yeah, I'm sorry, looking at the wrong thing too. The grid is helpful, but it's hard to look at on first glance. I saw Miss McLeod. Is Miss McLeod still here? Is this your case, Miss McLeod?
Good morning, Your Honor.
Good morning.
Who is this?
Ashley Bowden.
Number 12, Bowden.
I can't hear who you said. I'm sorry.
Ashley Bowden, number 12.
No,
That's not your client?
I don't believe so.
Okay. It says that she's a conflict case.
Okay.
Can you speak with her, Miss McLeod?
Yes, Your Honor.
Is there a number Miss McLeod can call over at ACDC?
No, not at the
They
moment.
can call me.
We can call you, Ms. McLeod.
Okay, you can call me now.
What's your number, Ms. McLeod?
404-457-2195.
Okay, we'll give you a call shortly.
Okay, thank you.
We can move on. Thank you, Ms. McLeod. Go ahead. We can move on to number 26, Harris.
Okay.
That's your client.
And are we able to do anything with interpretation yet, or no, at courtroom 2?
We're still waiting for him to be produced on jail court iPhone.
Okay, we're trying. All right, thank you, Ms. Chancey, for your patience. All right, Ms. Harris, your case is 17 CR 00280728. You're charged with theft by taking. Do you understand your rights today? Is that a yes?
Gotta speak louder.
All right, thank you. I don't have an announcement for this one. Mr. Ty, what's the announcement?
Your Honor, it's a time served offer, but it's a negotiated plea just because of the anti-theft course and probation requirements.
You said it's a non-negotiated plea?
Yes, Your Honor.
Okay, a lot of those today. Ms. Tyson, can I please have the history?
This is position 26, Sharita Harris.
Yes, ma'am.
Okay. I have 6 arrest cycles beginning in 1995, 1 FTA from 2024. Last arrest was in Atlanta, April 24th of 2017, and that was for theft by conversion. Disposition just states that time expired restriction. Looks like most recent misdemeanor conviction was for theft by shoplifting, and that was from 96. Nothing to add, Your Honor.
All right, Ms. Falk? Thank you, Ms. Tyson.
Yes, Your Honor. And just to clarify that, that theft by conversion is our case, the theft by This incident happened at so she was an employee at the McDonald's, which is located on 2135. Oh, sorry. Let me make sure I have the address correct.
Looks like Peachtree Road.
Correct. Which is the McDonald's at that location. The defendant had taken money from that location as part of her employment there, not as part of her job, but she stole money from that location at 2929 Peachtree Road and was then subsequently arrested. The reason we're asking for an anti-theft course, Your Honor, is although she does have not a significant history, her previous history does include theft, and so we believe she could benefit from an anti-theft course. We are agreeing to go non-reporting upon that completion of that course, so she complete that course quickly. She would then go on non-reporting probation as long as she stays away from that McDonald's at 2929 Peachtree Road, and we are agreeing to 12 months served, 24 days, credit for time served 12 days, from April 24th to April 26th of 2017 to August 8th of 2024 to today. Just to kind of head off that argument, the reason that this case has sat around for so long is because the defendant failed to appear both on August 27th of 2018 when this case was placed on the plea and arraignment calendar. It was then placed on a status conference calendar November 1st of 2022, at which she failed to appear again. So, but for the defendant failing to appear multiple times, this case would have been over back in 2018. That's all for the state.
How much was she alleged to have taken, Ms. Falk?
Let me see if I can pull the exact amount. $383.
Okay.
It was set for a deposit, a night deposit, and that's what she took.
All right, Mrs. Ty, please proceed.
Yes, Your Honor, as you heard from pretrial, she, I think that misdemeanor conviction was in 1996, I guess that's the other theft conviction. This happened in 2017, 7 years ago. She's had no arrests since then. I don't think she would benefit from an anti-theft course, and she has served 12 days, Your Honor. She did update her address with the court. She has moved several times. She has lived in Georgia all her life. I guess she didn't update her address. She, of course, is being held on the FTA. There's $1,000 bond on that. She is pleading guilty today, but just because of the age of the case and her very, very limited criminal history, she hasn't been arrested since this incident in 2017, so over 7 years. So I'm just asking for time served and the balance of probation suspended.
In 1 second. Ms. Strong, I'm sending you a message. I just want to look at one thing before I decide.
One moment, Judge.
Your Honor, and I'm only asking for the probation to be suspended because she hasn't been arrested in 7 years, and I don't want to set her up to be arrested, for a probation violation or not completing an anti-theft course. She doesn't have any significant history at all, and nothing in the last 7 years.
Okay, hold on.
1 second, Judge. Because it's a 17, we're looking it up. Just give me a second.
Okay, it wasn't recent, so that's okay.
No, ma'am.
Don't worry about it. All right. I've decided to give Ms. Harris a second chance. If she wishes to take the plea today, I would accept the defense's recommendation and allow it to be time served exclusively. Does she wish to take the plea?
Yes, she does. Thank you, Your Honor.
All right, Ms. Harris, please raise your right hand. Do you swear and affirm testimony you give today for the limited purpose of taking a plea will be a truth to the best of your knowledge?
I do.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you further understand that taking a guilty plea may affect other aspects of your life, such as employment or immigration or any probation, anything of that nature that we may not be able to anticipate today?
Yes, ma'am.
All right, as to the charge of theft by taking, how do you plead, Ms. Harris?
Guilty.
I accept your guilty plea. The time you served at the Fulton County Jail should close out your case. Is there anything additional?
No, I have, so since she did the time, sorry, we're doing away with the stay away, correct?
Correct, balance suspended.
Okay. Thank you.
All right. Best-
Wait, Your Honor, so there's no stay away from that location either?
Well, think about it.
Because
If
even with a balance suspended, they can do a stay away.
it's been so long, Ms. Falk, I'm not gonna require she stay away from that McDonald's, but I do understand this. You can go ahead and lodge your objection for the record. Go ahead, Ms. Falk.
Well, on behalf of McDonald's, I'm sure they don't want her back at that location, so we do object.
All right.
I also just want to make sure I covered the stipulation as to venue, factual basis, and identification for the plea. I
We
don't know
did,
if I
but let's do that
actually-
again on the record.
Thank
Ms.
you.
Atai, you do so stipulate to the 3 elements, correct?
Yes.
All right. And Ms. Harris, even though I have not directly ordered you to stay away from that McDonald's, it would be prudent for you not to return to that location. Find another McDonald's to go to, all right? Take care and good afternoon.
I think what I hear, they closing the way, so. we gotta see it. So,
All right. Harris.
bye.
All right, who do we have next?
Number 13, Brooklyn.
All right, Ms. Brookins has the FTA, that's 14 and position 13. All right, Ms. Brookins, your case is 22 CR 006424G. You're charged with destruction of a mailbox and criminal trespass. Do you understand your right?
Yeah.
All right, I don't have an announcement for this one. What is
It should be, Your Honor, I think it is a non-negotiated.
Is that what we're gonna do all day? We're not
I'm
able to-
sorry, Your Honor. I mean, I don't like restitution being open for 30 days. I mean, this is 2 years old. I don't know why. I mean, Ms. Fox.
Okay, so,
They should
all
know
right,
what
so Ms.
restitution is.
I keep trying to get us finished by lunch and we just can't seem to get there. All right, let's go with, wait a minute, I see jail court iPhone. Can we do something with that before we begin this one?
We have position number 28.
Is that the one that needs interpretation?
No, I don't think he understands. He speaks.
I understand. Speak English.
So we don't need Miss Chancellor today, is that correct?
It's position 39 that needs the interpreter.
39, are we gonna be able to take the phone to the person who needs to be interviewed? Or no?
Who?
Do you want to take position 28 now?
I guess, can we, I was hoping let's take 28 so the phone can make its way over to interpretation. I'm sorry, just hold for 1 second for me, Ms. Brooklyn, okay? All right, so let's go to 28 very quickly. I have 28 is Violet Jarrell.
Yes, ma'am.
All right, your case is 24 CR 004793A. I'm not gonna sound the charge, and it's a criminal trespass as well. What's the announcement for this case, Mr. White?
To negotiate a plea, Judge. He was
All right.
actually reset, he was reset last week, he's supposed to be added onto a calendar, and he wasn't subsequently, so he's been here, I think, about a week longer than we anticipated, so.
Okay, understood. Ms. Falk?
Yes, Your Honor. The state's recommendation on this is 12 months concurrent with count 2. Stay away from Grady Hospital unless it's for medical necessity. On count 2, the state's recommendation is a 12-month probation sentence, served 45 days, credit time served 22 days from July 16th, 2024 until today. Balance probated. We are requesting an SDET, as well as, again, that stay away from Grady unless it's for some medical necessity. Just very briefly, the defendant was at that location at Grady Hospital at 80 Jessieville Junior Drive, refused to leave the property after receiving treatment, was told to do so several times by Grady Hospital public safety officers, was then escorted off the property, but then returned. And then when she returned, she removed all of her clothing, and sat on top of the Clayton County patrol vehicle. And so that was the basis for count 2. And that is the state's recommendation. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
Do you so stipulate, Mr. White?
Judge, we stipulate, there is a correction on the amount of time, though, it's more than 22 days.
That
Okay.
is correct. Just to get the exact number of days, Mr. White is correct about that. There were added numbers of days based on the defendant being in custody. So the defendant has now been in custody for 29 days.
Okay, so we'll make that adjustment. All right, please raise your right hand so that I can ask you some questions and make sure this is a voluntary plea. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, Your Honor.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, I've agreed to take a no-low plea.
All right, did anyone promise you anything in exchange for taking a plea?
No, just the agreed to terms with Ms. Falk. No, nothing else.
Just say yes. No, okay, I don't want you to say too much, okay?
Okay.
And you understand the requirements of the sentence?
I do for the most part. I just don't understand because I never received treatment from Grady. They refused me treatment. That's why I did what I did. I was trying to get help for a suicide attempt at the hospital.
Okay, I don't want you to say too much. Do you wish, let's go back for a second. Do you want to take a plea to this charge today?
I do. I want to take a plea and go home and go back to school. Yes.
Yes or no? Please.
All right, please, yes. Okay, so let's backtrack. Okay, are you satisfied with Mr. White's representation?
I am.
Has he fully explained the terms to you such that you feel comfortable moving forward, taking the plea and understanding what's happening?
Yes, I do.
All right. And you understand you're giving up your right to trial?
Yes.
And you're giving up your right to make the state prove this charge against you beyond a reasonable doubt?
Yes.
And you further understand that this may affect other aspects of your life, such as employment, immigration, probation, things of that nature?
I do.
All right. As to the charges previously listed, how do you plead?
No-low.
All right. Did the state have an objection to the no-low plea?
State does not have an objection, and the defendant is eligible for NOLA.
No-low plea. All right. I accept your no-low plea. Is there anything additional from you, Mr. White, or Ms. Falk?
I'm sorry, you faded out at the last second there.
Yeah.
Oh, I asked if there was anything additional.
Nothing from the state.
All right. Best of luck to you. All right. Take care.
Okay, when will I be released? That's the question.
If you don't have other holds, I can't say exactly when, but they're gonna begin processing you out. All right.
Okay,
Hopefully
thank
soon.
you.
All right.
And there are
Have a
no
great
other
day.
holds, Your
Thank
Honor,
you.
just to let the court know and to let the defendant know.
All right.
What
good.
happened?
There are no other holds on you.
There
so
are
you
no
should
other
be
hope.
released
Thank you,
today.
ma'am. Have a
Not a
blessed
problem.
day.
All right. They're
Take
gonna
care.
be processing you out. Take care. All right. We're gonna go back to Ms. Brookins. And can the phone try to make its way over?
The DA was on it. She was like,
What's the case with the interpreter? Who's that?
Last name is it Ramos? Marvin Ramos?
Okay, I'll make my way. I'll make my way to him.
thank
Thank
you.
you.
The interpreter is for Sriracha. Position 39, I think.
All right, so we're gonna go back to Ms. Brookins. Ms.
Welcome
Brookins,
to
our
Sriracha.
regular case number, do you understand?
He's in ACDC.
I can't hear you.
Yeah.
I said, did you understand your rights today, Ms. Brookins?
Ma'am.
You understand your rights?
Yes,
Latonia?
ma'am.
Okay, understood. It's non-negotiated. So we're gonna go to Ms. Tyson.
Your Honor, the state is willing to waive the restitution being open for 30 days. So this is a negotiated plea.
Okay, is it otherwise negotiate, it's now negotiated, Mr. Ty, with the deletion of the resolution?
Yes, I appreciate that. Thank you, Ms. Falk. I would like to let the court know that she is young, 23 years old. She does care for her brother, her younger brother and sister, and two children, a 4-year-old and a 1-year-old. She did become homeless as a result of this incident in 2022. But because she had a stay away order, she has gotten herself back on her feet. She does have an apartment in Jonesboro. She worked several jobs at La Quinta, in McDonough, and also at Wendy's. She did graduate from Rockdale High School and attended some college online. After this case, she was living at the East Point train station. Like I said, she's gotten herself back on her feet. I would also just like to ask for the probation to be suspended, the balance of probation be suspended or fees to be waived.
PD tie that it would suspend the probation because there's no restitution at this point.
Oh, okay. Sorry.
Let's let Ms. Falk put her recommendation onto the record. Ms. Falk, please proceed.
Yeah, just really briefly, the facts of this case are that the defendant went to 81 Allen Temple Court Northwest, which is the Commons apartment complex, tried to break into the mailboxes by using a metal object, and was witnessed by security breaking into those mailboxes. The state's recommendation is going to be count 1 will merge with count 2. Count 2 is 12 months served 20 days, credit for time served 10 days, 9/22/22, and August 5th of 2024 to today, balance suspended, stay away from the Commons apartment complex at 81 Allen Temple Court Northwest. That's all for the state. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
We stipulate.
All right, Ms. Brookins, I'm going to place you under oath. Please raise your right hand. Do you swear and affirm testimony you give today be the truth to the best of your knowledge? Is that a yes?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this date that would affect your ability to understand this proceeding?
No, ma'am.
Are you satisfied with Mr. Ty's representation?
Yes, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand taking a plea, you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life, such as employment, immigration, probation, things of that nature?
Yes, ma'am, I do.
All right. As to the charge of criminal trespass and damage, how do you plead, Ms. Birkin?
I plead guilty.
All right, I accept your guilty plea, and there shouldn't be anything additional from the state of defense, but I'll still ask.
Position 14, we are entering a null pros, and I have sent that over to Ms. Strong.
Thank you. Anything additional, Mrs. Ty?
Nothing further. Thank you.
All right.
And you're on position number 39, the Spanish interpreter cases at ACDC.
Oh, okay. I didn't know that.
I apologize. Can you run down the plea for Brookins one more time because I missed it?
Oh, yes, Ms. Strong, that's not a problem. Count 1 will merge with count 2. Count 2 is 12 months served 20 days, credit for time served 10 days, balance suspended with a stay away from the Commons apartment complex at 81 Temple Court Northwest.
Thank you.
Not a problem.
Okay, so position 38 is at ACDC?
39.
I'm sorry, 39. Not the interpreter case, though. Okay.
That is the interpreter case. 39.
Okay, it's Sriracho is the one that needs interpreter, not Ramos?
Yes.
Okay, understood. So can we put Ms. Chancey in a breakout I don't even know how we're gonna do this.
Judge, I would have to go get them. So.
Okay, so do you want to finish?
And I'll put them in the breakout.
Okay, so do you want to finish who you have there and then go get position 39?
Yes, this is gonna be my last one, and then I'll go get number 39. Well, I can do that.
All right, who is it that we have now?
Hey, sir, you're going. Come on. We
All
can
right.
go with position 8 and 9, Mr. Elia Benton.
Okay.
Says Elia.
All right, we'll do, so 8 is the FTA. All right, good morning. Your case is 23 CR 008413A. You're charged with battery on
I ain't
a
trying
transit
to-
station.
I mean, I ain't trying,
Who's
I ain't
speaking?
trying, I'd rather do my 28 days and get it over.
Okay, well, before we do anything else, you understand your rights?
Yes, ma'am.
All right, Mr. Ty, seems like the announcement may have changed. What's your announcement now?
Your Honor, he, over my advice, he does want to plead guilty. I would ask, if he's gonna serve the 90 days that the state is requesting, I would ask for it to just be a time served with no probation or anything after that. He's willing to plead guilty, stay in jail for 28 more days, but I don't want him to be on probation after that. Of course, stay away from MARTA is fine, but, the
Okay.
12 anger management and community
It's
service.
It's non-negotiated again. Okay, so let's do this. Ms. Tyson, can I have the history, please, to help inform? The only reason I'm cutting you off, Mr. Ty, is the history will help me if we just go in a little bit
I
of order.
understand. Thank you.
All right, thank you. So, Ms. Tyson?
8 arrest cycles beginning in 2015. Looks like we have a case out of Fulton County from November 2015, possession of firearm or knife during the commission of purchase, possession, manufacture, distribution, or sale of marijuana. Looks like he received PTI for that case, and case was dismissed June of 2016. We have another case, felony case out of Cobb County for aggravated battery, disposition date October 28th of 2021. Received 2 years confinement, 3 years probation. And he received first offender treatment on that case, no seal date, Your Honor. Oh, and possession of firearm or knife during the commission of, with probation of 5 years on that case. So no seal date's been provided yet. There's a misdemeanor conviction out of Cobb County for battery from September 23rd of 2022. We have a violation of probation from 2 from 2024, and then 1 FTA from 2024 as well. Nothing to add, Your Honor.
Thank you. Ms. Falk?
Yes, Your Honor. So the reason state's recommendation is the way it is because of the case that he's still on first offender for aggravated battery and for possession of a firearm or a knife during commission of a felony. That's actually an 8 serve 2 sentence. The 5 years was consecutive to the 3 years. And the second case was his very next case was a battery out of Cobb County for which he was convicted. And now this case happened December 27th of 2023. The defendant, Eddie Fields, had a large laceration to his upper lip. The officers were advised that the defendant, Mr. Fields stated the defendant stood up over his seat and asked him why he was looking at him. And before he could answer, the defendant punched him in the mouth. Multiple patrons also advised that the defendant just hit the victim, Eddie Fields, causing a large laceration to his lip. So this was an unprovoked attack by a person this victim did not know. Mr. Fields did not know his attacker. And for that reason, based on the history, which is literally all violence, other than the first case, which was a drug case, and now probation violations, we ask that the defendant be given a 12-month served 90-day sentence, credit for time served 16 days from December 27th to December 29th of 2023 and August 1st, 2024 to today. Balance probated, no further contact with Eddie Fields, stay away from all MARTA facilities, 12 weeks anger management, 40 hours community service, and no firearms. We would like to sound for Mr. Eddie Fields and do ask the defense stipulate to venue factual basis and identification for the purposes of this plea. This plea will result in a null pros of position number 8, which was the FTA.
All right, is Mr. Fields present? I don't see him. And I'm sorry, ACDC, you're back. Can we put them in the breakout. Oh, does Mr. White have a laptop so that we can do the interview while this is happening?
Judge, I do have a question. I'm sorry to interrupt. Is it possible that I can still do Bowden? Because I wanted to get done with all the females and then bring all the guys over. Bowden still needs to talk to Miss McLeod.
McLeod, yes, we can do that. Has Ms. McLeod spoken?
No, I'm gonna do that now.
Yes, that's fine. Let's do that.
Thank you.
Thank you. Okay, I'm sorry. Go ahead, Mr. Ty.
Your Honor, he is willing to plead guilty. The state's offer requires him to serve 28 more days in custody. He's pleading guilty, but he states it was not an unprovoked attack. He's taking responsibility for it, but he states that the complaining witness passed gas right in his face on purpose, looked back at him, told him he's gonna urinate on him. So, I mean, he's admitting that it became physical and there was a fight, but he doesn't admit that it was an unprovoked attack. He's lived in Georgia all his life. He graduated from North Druid Hills High School. He was working at Carolina Lumber for the last year. He does have a 2-year-old child. He does, I understand that he has some history, Your Honor, but the state's asking for 90 days to serve here. He has 28 more days. I just don't want him to have to report to probation and take anger management and serve community service. Stay away from MARTA is fine, but I just ask that it be time served after the additional time that he'll spend in jail.
Okay, if the defendant takes the plea, I am gonna accept the state's recommendation. So do you want to speak with him again and see if this is actually what he wishes to do at this juncture?
What you mean, what did you say?
Why don't you mute
Yes,
or-
Your Honor, I need a minute.
All right, we'll be on a very, very brief hold. All right, Mr. Ty.
Your Honor, he wants to plead guilty.
All right. All right, Mr. Benton, please raise your right hand. Do you swear and affirm testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
And you understand that you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you are satisfied with Mr. Ty's representation?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life?
Yes, ma'am.
And you fully understand the requirements, including the community service, the classes you have to take, as well as the requirement that you stay away from MARTA facilities?
Yes, ma'am.
All right, as to the charge of battery in a public transit station, how do you plead, Mr. Benton?
Guilty.
I accept your guilty plea. Is there anything additional from state or defense?
Nothing from the state.
All right, best of luck to you, Mr. Benton. Who do we have next?
We can go to position number 18, Mr. Jordan Crowe.
Okay. Mr. Crowe, your case is 24 CR 005317B. You're charged with obstruction, public drunk, possession, and trespass. You understand your rights?
Yes, ma'am.
All right. The announcement I don't have an announcement. What is the announcement, Mr. Ty?
Your Honor, this is a non-negotiated plea just to address the $300 fine and the 40 hours of community service
Okay.
and probation.
Ms. Tyson, can I have the history, please, since it's not negotiated?
I apologize. Who is this again? What position is this?
Number 18.
One moment. You said position
18. Pro.
18, I'm sorry. We have 5 arrest cycles beginning in 2022. Looks like there's a case out of Fulton County, marijuana possession less than 1 ounce and possession and use of drug-related objects. Arrest date was August 17th of 2022. No dispositions listed on the GCIC. See, there's another case from December 9th of 2022. MARTA Police Department arrest an agency for criminal trespass, willful obstruction of law enforcement officer. There's no disposition listed for that case either. There's an arrest out of DeKalb County, February 17th of 2024 for theft by shoplifting misdemeanor. No dispositions listed for that case. And then we have another arrest from April 17th of 2024 for MARTA Police Department, criminal trespass, no disposition listed. And last arrest was June 12th of 2024 for possession of marijuana less than 1 ounce and criminal trespass by MARTA Police Department. No dispositions listed for that case either. Looks like he has, 1 second. "16 cycles out of Texas. Last arrest was November 19th. Yeah, November 19th of 2020 for assault causing bodily injury, family member. No dispositions listed for that case. Looks like he has a felony conviction from May 15th of 2019 for assault, family member, impeding breath or circulation.
Okay, that's good. Thank you.
Okay, you're welcome, Your
All
Honor.
right. Ms. Fall?
Yes, Your Honor. In this particular case, this happened July 29th of 2024 at 65 Joseph E. Lowry Boulevard, Southwest in Atlanta. The defendant was seen smoking a green leafy substance in front of the Ashby MARTA train station. He was advised to hand over the marijuana, but refused to comply. He then began drinking Old English malt liquor beverage in front of the officer, had slurred speech, displayed aggressive and boisterous behavior, refused to comply with the officer's directives, hindered the officer by pulling away and not allowing the officer to effect an arrest. And he remained on the MARTA property, knowing that he had a permanent ban from MARTA property, as well as having another gram of marijuana on his person. The state's recommendation on this case on count 1 is 12 months served 32 days, credit for time served 16 days. From July 29th of 2024 to today, balance probated, stay away from MARTA, 40 hours of community service. Count 2, the willful obstruction, 12 months concurrent with count 1 with a $300 fine, which is statutory. Count 3 is the public drunk, 12 months probation concurrent with count 1. Count 4, we have agreed to null pros. I do want to point out the defendant entered guilty pleas on June 27th, 2024, about a month before this case, on 24 CR 003744Y and 22 CR 008207Y. He was sentenced in front of Judge Lull and is currently on 12 months probation on those cases with a stay away from MARTA. The judge agreed to waive probation fees until September 2024. So the reality is we're more than happy to run this concurrent with the probation he already should be on, but he's going to be on probation either way. That's all for the state. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
All right, do you so stipulate, Mr. Ty? I know you have some objections, but do you stipulate on the record first?
We stipulate, Your Honor, and
the $300 fine, it is the statutory fine, so there's not much we can do with that. So what's the other basic?
Your Honor, you can waive statutory fines.
Or turn it into community service.
I could turn to community service. I would do that, but I would
You
not waive
can,
the.
but you don't have to. You can waive all of that. Your Honor, he is 34 years old. He has been homeless, as you can see from his history, for the last 2 years. He's been looking for jobs for the last 2 years. He does do daily work. He tells me that he also pays child support. He tells me the last time that he got a paycheck, it was for 32 hours of work, and he received $108 after child support was taken out of that. He cannot afford a $300 fine, and he's not in a position to do community service. I think that reporting to probation is enough in this case. I think I saw that he is reporting to probation for a case where he pled guilty to possession of marijuana less than an ounce. I mean, I think the probation that he has already is more than enough. And I just asked to waive the $300 fine and the 40 hours of community service. He has he has enough trouble providing for himself and for his children who he pays child support for.
All right, if he takes it today, I am gonna require that he complete the community service, but I would convert the $300 fine into community service as well. Does he wish to take the plea, Mr. Ty?
How much community service would it be?
I'm always bad at that math. I believe it would still be 30 hours, so he would have to do 70 total within a year. Does he wish to?
Yes.
All right. Mr. Crowe, please raise your right hand. Do you swear and affirm the testimony you give today for the limited purpose of taking the plea will be the truth to the best of your knowledge?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking the plea?
Just what's been stated.
Okay, but no specific gifts or anything of that nature.
No, ma'am.
Are you satisfied with Mr. Ty's representation?
Of course.
And you understand that taking a guilty plea may affect other aspects of your life?
Yes, ma'am.
And you understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
All right, as to the charges I previously listed, Mr. Crowe, how do you plead?
Yes, sir.
I accept your guilty plea at this time. Is there anything additional, Mr. Ty or Ms. Falk?
Nothing from the state.
Nothing, Your Honor, just confirming that this probation will run concurrent with the probation in the other case, the 744Y, and there's no fees until September 2024.
I believe so, and if we wanna, what we'll do is I'll give him an additional month of waived fees, so, what was it, September? We'll make it October. We'll make it October. All right?
Okay, thank you, Your Honor.
All right, best of luck to you, Mr. Crowe.
Thank you.
Who do we have?
We can go to position number 20, Mr. Mario Dawson.
All right, Mr. Dawson, your case, oh, he's not there yet, is he? Your case is 24 CR 005220G. You're charged with 2 counts of obstruction, 1 count of criminal trespass, and 1 of shoplifting. You understand your rights?
Yes.
All right.
Yes.
Thank you. I appreciate that. The announcement I have is that this is also not negotiated. Is that correct?
Yes, Your Honor. Okay, I won't start yet.
Thank you. I know. All right, Ms. Tyson, since it's not negotiated, can I please have that history?
22 arrest cycles beginning in 2022. In the last 10 years, he has a felony conviction out of Fulton County for 2 counts of aggravated battery. Disposition date on that case is May of 2016. Looks like he has a misdemeanor conviction out of Fulton County for theft by shoplifting. He took a NOLO plea on that case March of 2019. He has another misdemeanor conviction out of Fulton County for disorderly conduct. Let's see, that's from August of 2022. He has an arrest from February 27th of 2024 for simple battery out of Fulton County. No dispositions listed on that case. His last arrest was July 27th of 2024 for willful obstruction of law enforcement officer, 2 counts, criminal trespass and theft by shoplifting.
That's this case. Right? I think so. Okay.
Is it? Let's see.
Yeah, I think so. It's
Okay,
July
okay.
7th.
Yes, that's correct. That is correct. I'm sorry.
No, that's okay.
Last arrest was May 4th. I'm sorry, May 4th of 2024, Fulton County. I'll waive sounding on one charge. The other charge is possession and use of drug-related objects. He received a probated sentence on that case. That case was 24 CR 003401G. He has one violation of probation from 2019 and another from 2018. Nothing to add, Your Honor.
All right. Thank you, Ms. Tyson. Ms. Falk?
Yeah, I have a lot more that wasn't covered. So there are 2 counts of the battery of which sounding was waived. That was a final disposition on July 16th of 2024 before, I cannot read that signature of that judge. I'm not sure which judge it was before, but the defendant was given a 12-month probation sentence, served 74 days, stay away from 800 Peachtree Center in Atlanta, Georgia, was also given a stay away from Ebony Rush and Nikita Rao, as well as SDET. There's then a battery of which the court asked for a waiver of sounding and a possession of drug-related objects. He entered a plea on that case on May 21st of 2024 before Judge Morrow. He was to stay away from Ponce City Market on that case, as well as have no further contact with Corey Hawthorne, and was placed on probation on that case. He then had a 2024 simple battery case where he entered a plea on March 21st of 2024. On that case, he was given 12 months, 100 days to serve, credit for time served 24 days. That was a stay away from 535 Lee Street Southwest, which was a Texaco. He then had a 2022, criminal damage to property in the 2nd degree. He entered a plea on that before the Superior Court on 23 SC 189949. He was given 2 years commuted to time served on that case. And that looks like it was Judge DeFore on January 24th of 2024. He then had an affray, which he was found guilty of September 14th of 2023. That was also in Fulton County, 23 CR 005061G. He was given 12 months, served 38 days, credit for time served 19 days. That was signed by, Your Honor, on September 14th of 2023. He had a willful obstruction and disorderly conduct, 22 CR 005310D. He entered that plea on August 18th of 2022 before Judge Law, and was given probation on that case. Prior to that, he also had a 21 CR 004359D, theft by shoplifting. He entered NOLO on that on September 2nd of 2021. Before that, 21 CR 002955G. He entered a 12-month probation plea on a theft by taking misdemeanor and a battery in a public transit vehicle. He was sentenced on July 6th of 2021 before Judge Morrow. He actually unsuccessfully completed probation and was terminated September 21st of 2022. And then previous to that, September, he had a plea on a willful obstruction of law enforcement felony. That was November 30th of 2022, where he entered his plea on that case and was given confinement. So I just give that information to give Your Honor a little bit more of an idea of this defendant's wide-ranging history. That's just in the last 3 years that he entered all of these pleas. On this particular case, the officers were called out to Chevron Food Mart at 343 Joseph E. Lowry Boulevard Southwest on July 27th of 2024. They made contact with Mr. Gaba, who is the store clerk, who stated the defendant entered the location went and took a 12 pack of Corona beers. He then went and kicked the door open, knocking the front door off the hinges. Officers were able to watch video footage of the incident where the defendant walked in, stole the beers, and then kicked the door off its hinges. They then reported out as a bolo. They did advise they saw the defendant drinking one of the beers, and then he walked off after the officers tried to make contact with him. He was asked to stop, but began running with the beers, running in and out of traffic, was pursued on foot, and then he was apprehended. The state's recommendation is based on his wide-ranging and, quite frankly, lengthy history. We are recommending 12 months probation concurrent with count 4 and a $300 fine on counts 1 and 2, the willful obstruction. We are willing to merge count 1 into count 2, so there's only one $300 fine. We are asking that restitution remain open for 30 days. This just happened less than 30 days ago, and we would like to see if there is any restitution for the damage to the door on count 3, the criminal trespass, and count 4, the theft by shoplifting, is 12 months served, 36 days, credit for time served 18 days from July 27th, 2024 to today. Stay away from Chevron Food Mart at 343 Joseph E. Lowry Boulevard Southwest in Atlanta. An anti-theft course, a $500 fine, which is statutory, and 40 hours of community service. Both the $300 fine and the $500 fine are statutory. Obviously, Your Honor can convert that to community service, but I would just like to point out that this defendant was just most recently sentenced before this court, even if it was not directly before Your Honor, I believe it was just about a month ago, and is already back out stealing and causing damage. I feel like this defendant has had several bites at the apple. He was just sentenced July 16th. It was been less than a month, and he's back out doing committing a theft. So that's all for the state. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
All right, do you so stipulate, Mr. Ty, before you give me your objection?
Yes, Your Honor, we stipulate. And I understand that he has a criminal history. He has been homeless for at least the last 3 years. He is disabled, Your Honor, and all of that history does not change the fact that he's homeless and he has a significant financial hardship. It's not even, yes, you may convert the fines and statutory surcharges and probation fees to community service, but the statute states that you shall waive, modify, or convert fines and the other fees upon a determination by the court that the defendant has a significant financial hardship. It doesn't say upon a determination that he has little criminal history. He has a significant financial hardship. And I would ask, of course, he cannot afford $1,100 or $800 of fines. I'm sorry, I don't know who's on from probation, but there aren't any low cost programs for 12-week anger management. There aren't any free programs either. The probation is a for-profit company, Your Honor, so they're not offering free services to our clients who are on probation. They rake in millions of dollars a month. So he can't afford an anti-theft class. He can't afford the fines. He's okay with, he told me he'd rather do as much community service as necessary. And he states that he may be able to do that through Gateway or one of the shelters that he received services from for the last several years.
Okay.
So, Your Honor, it's time served. He just can't pay the fines and probation fees.
Okay. If he takes the plea today, Mr. Ty, I would convert all fines to community service at that at the amount. So it would be 30 for count 1. I would leave the restitution open for 30 days. And I would still require the theft course, but I would convert the $500 fine to community service. So that does turn into quite a lot of community services. Your client still want to take the plea?
Yes. Your Honor, did you say you're leaving restitution open?
Yes, I would do that. The restitution would remain open for 30 days.
So he'd have to return for a restitution hearing?
Yes. Does he want to take the plea?
I mean, I feel like he's been in custody for 18 days. I don't think it would have been difficult for the state to get in touch with the complaining witness and see what the damage to the door is.
Okay, well, I understand that, but I've already decided I would leave it open. So does he want to take the plea or no?
It sounds very right.
Yeah. Yes, he wants to take the plea because he wants to get out of jail.
Okay. All right, sir, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes,
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
no,
Are you satisfied with your attorney's representation?
yes, Your Honor.
Did anyone force you to take a plea today?
No, Your Honor.
Did anyone promise you anything in exchange?
No, Your Honor.
And you further understand that you're giving up your right to trial by judge or jury?
Yes, Your Honor.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, Your Honor.
And you further understand the requirements that you cannot go back to that location. You're gonna have to take an anti-theft course and complete 120 hours of community service. You understand that, Mr. Johnson?
Yes, Your Honor.
And you further understand that taking a guilty plea may affect other aspects of your life, such as employment, immigration, other things of that nature.
Yes, Your Honor.
All right, as to the charges I previously listed, Mr. Dawson, how do you plead?
Yes, Your Honor.
I will waive 3 months of fees to get him started. All right? Is there anything additional from state or defense?
Your Honor, could you please tell me how many hours of community service is there?
120.
Can we run down the plea completely one more time, please?
Say that again, Ms. Strong.
Can we run down the plea completely one more time?
Okay, so first count will be 12 months probation, and he's
I'm sorry, somebody, I don't know if it's muffled, so I can't hear you.
oh, maybe it's me. Ms. Falk, will you repeat it for me? And I think it's, can we mute jail court iPhone? I think that's the issue. Is that better? All right, Ms. Falk, will you run it for me?
Okay. So I did agree to merge count 1 into count 2 for the purposes of the plea. So we only had one $300 fine. Count 2 is going to be 12 months. Sorry, Ms. Strong. I see you putting your finger up. Let me stop.
You said so 1 and 2 are
Right. So count 1 will merge into count 2.
Got it. Go ahead.
Count 2 is 12 months concurrent with count 4, $300 fine.
That's being converted to 30 hours community service.
That is correct. Count 3, let me know when you're ready. Okay, count 3 is 12 months concurrent with count 4, restitution open for 30 days. Okay, count 4 is 12 months, served 36 days, credit for time served 18 days. That's going to be from July 27th to today. Stay away from the Chevron Food Mart at 343 Joseph E. Lowry Boulevard, Southwest in Atlanta. An anti-theft course. The $500 fine is going to be converted to 50 hours of community service. And then there's an additional 40 hours of community service. So there is a total of 120 hours of community service. And the anti-theft course. And then the 12 months probation, served 36 days, credit for time served 18 days.
Okay.
Okay.
Thanks.
All right, is there anything additional from state or defense?
Nothing from the state.
Nothing further.
And I did waive 3 months of fees. All right, best of luck to you, sir. Who do we have next?
Yeah, position is 42 and 43.
Okay, Mr. Thornton. Mr. Thornton, your cases today are 24 CR 003211A. In this case, charge of simple battery, and 24 CR 005293A. You're charged with battery and theft by taking. You have a right to remain silent. You have a right to an attorney, and I'm conducting this hearing by video. Do you understand all of that?
Yes, ma'am.
All right. What is the announcement?
What position are we on? Sorry.
42 and 43.
Where is Mr. Thornton? I was just spoke to him yesterday.
That jail court iPhone. I guess he's somewhere else.
Okay, really quickly, Ms. Falk, I know you've been in court all day, but can you check your text real quick on Mr. Thornton?
Can I check my pardon?
Your text, I texted you about him, just one thing.
Oh, okay.
Yeah, I don't have any announcement for this one.
Okay, so when you say on this charge only,
Right.
okay,
Right.
3211.
Right. He only had 4 days in custody. So I'm trying to make them even. I'm trying to make both counts even, and get out at the same time.
But they are. Okay. Okay, I see what you're talking about. Okay. Yes, I can agree to that.
Okay, Mr. Thornton, the issue we discussed yesterday on the simple battery, they're gonna make them both the same.
So is it negotiated plea at this point?
Yes, Your Honor.
Okay, yeah, okay.
Okay.
Yes, ma'am. Okay.
Right.
Okay.
Okay, we worked it out.
All right, Ms. Falk, please proceed since it's negotiated.
Yes, Your Honor. So there are 2 cases. The first case is going to be 12 months serve, and this is a modification. So Ms. Strong, you're definitely going to need to make the correction on this. It's 12 months serve, 44 days instead of 56. Credit for time served 4 days from May 23rd to May 26th of 2024. Balance probated, no further contact with Emerita Dixon, stay away from 3107 Church Street in East Point. That case, Your Honor, just briefly happened May 23rd of 2024. Excuse me, I misspoke. May 20th of 2024, the defendant punched the victim in the face with a closed fist. It did cause swelling to the left side of her face. And that was after she had called the police and instructed them that they had had an argument. A witness observed, identified as Miss Little, stated she did observe both parties arguing, and Mr. Thornton approached Miss Dixon and shoved, Mr. Thornton approached Miss Dixon, shoved her, and then hit her with a closed fist in the face. And so that was observed by a second party. On the second case, Your Honor, which also involves Miss Emerita Dixon, who is here on the Zoom, that recommendation as to the battery is 12 months served, 60 days, credit for time served for 16 days. That's also going to include family violence intervention program, 40 hours of community service, no further contact with Miss Emerita Dixon, as well as no firearms and a stay away from 3107 Church Street in East Point. Count 2, the theft by taking, is going to be a time served plea, 32 days, credit for time served, 16 days. In that case, Your Honor, this incident happened on July 29th of 2024. Officers were approached by Miss Dixon. She stated that during a verbal altercation, the defendant punched her in the face. After he punched her in the face, he took 2 phones out of her purse. One was an iPhone 7 and one was a Motorola phone. She did state they had been dating for the past 2 years and used to reside together. We have had a chance to speak with Miss Dixon. When we spoke with Miss Dixon, she indicated to us that the defendant does have 2 open had the previous case and also an open case under 24 PI 000484. She stated they do have a toxic relationship. She does not want contact with the defendant, and she did confirm the events in the warrant and stated this is not this is not the first time the defendant had been violent with her and not the first time he had been arrested for violence against her. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
Defense stipulates.
And we
You
would
should-
like to stop for Miss Emerita Dixon, Your Honor.
Question, how much additional time is he serving? If he takes these pleas today?
The way I calculated it is it will be, he said 16 days, 45, 14 more days,
15 more days?
14.
14 more. Okay. All right, is Ms. Dixon present and wishes to make a statement? If so, please turn on your camera, raise your right hand. You are not required to make a statement, but this is your opportunity to do so. Okay. Ms. Melnick, you did stipulate, and that was your understanding of the offer?
Yes, Your Honor.
All right, Ms. Thornton, I'm gonna ask you some questions to make sure this is a voluntary plea. Can you raise your right hand, please? Do you swear and affirm the testimony you give today be true to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that taking a guilty plea, you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you understand the requirements that you're going to have to serve an additional 14 days. Upon your release, you have a class to take, community service to complete, and you are to have no contact with Ms. Dixon and stay away from that location. Do you understand that?
Yes, ma'am.
And you understand taking a guilty plea may affect other aspects of your life, such as employment or immigration or other things that I may not be able to anticipate?
Yes, ma'am.
All right, as to the charges I previously listed, Mr. Thornton, how do you plead?
I plead guilty.
I accept your guilty plea. Is there anything additional, Ms. Melnick or Ms. Falk?
No, Your Honor.
All right,
Thank
best of luck to you, Mr. Thornton. That concludes your
Thank
case.
Okay, thank you.
All right, have a good afternoon.
Okay.
All right, and we're going back to ACDC. Did Ms.
Yes.
McLeod have the opportunity to speak with this young lady? I forgot what position was this, Benton?
It's gonna be number 12, Bowden. Yes, she did.
Wow.
Ms. McLeod.
Okay, so what is the announcement, Ms. McLeod? Are you still here? I don't see Ms. McLeod.
We did have a question for number 19, Daniels. I was told that she was at Georgia Regional, but she, however, came back to, she's actually at ACDC. Has anybody got a chance to interview her? Ms. Holden?
Yes, I did. I spoke with her yesterday.
Okay, so I'll bring her next.
Okay, well, I don't think we can take Ms. Bowden. Ms. McLeod's not here.
Okay,
So, and
I'll just come back then.
okay, and we
I'll
still,
grab Ms. Daniels.
okay, and we still can't do the interpretation case yet, can we?
No, not until I take all the females back, and then I'll bring the guys.
Okay,
Thank you.
okay, thank you. All right, who do we have now?
Positions 44 and 45, Mr. Tilground. Oh, okay.
Okay, and is he coming, or is this a waiver, or what are we doing?
Tilground?
Yes, Tilgram, what is the announcement? Oh, Mrs. at medical. What's the announcement that for that case?
It's gonna be a plea, Your Honor.
Is a negotiated plea?
Yes, Your Honor.
All right, thank you. Mr. Tilgram, your case is 23 CR 007653E. You're charged with criminal trespass and you also have a PA today. You have a right to remain silent. You have a right to an attorney. And I am conducting this hearing today by video. That means any member of the public can log on and watch this. Do you understand your rights and how I'm conducting the hearing today?
Yeah, ma'am.
All right, thank you, Ms. Paul.
Yes, Your Honor. This incident happened back on December 1st of 2023. The defendant officers were dispatched to 205 12th Street Northeast Piedmont House in reference to a defendant who refused to leave. He had been previously given a trespass warrant, and he then returned to the Piedmont House after being given a trespass warrant, and where he was staying inside the stairwell after being asked to leave numerous times. We do ask the state's recommendation is 12 months, serve 32 days, credit for time served 16 days. That's going to be from December 1st to December 3rd, 2023 and August 1st, 2024 until today. Balance suspended. Stay away from the Piedmont House located at 205 12th Street Northeast in Atlanta. We are agreeing to null pros position 45, and we do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
Yeah,
And
stipulates.
And that was your understanding of the offer?
Yes, Your
Yes.
Honor.
All right. Mr. Tilgham, please raise your right hand so I can place you under oath. Do you swear in the firm testimony you give today be the truth to the best of your knowledge?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yeah.
Did anyone promise you anything in exchange for taking a plea today?
No.
Did anyone force you to take a plea?
No, ma'am.
And do you understand that taking a guilty plea, you're giving up the right to trial by judge or by jury?
No, ma'am.
And you further understand you'll have no other court dates regarding this charge?
No, ma'am.
And you understand that you cannot return to that location by the time you serve to close your case?
Yes, ma'am.
And you understand that taking a guilty plea may affect employment, immigration, probation, or other things that we may not be able to anticipate.
Yeah, ma'am.
As to the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from state or defense?
Nothing, Your Honor.
All
No,
right.
Your Honor.
All right, best of luck to you, Mr. Tilgham. Take it.
And the other count, which will be no frost fingerprint charge.
Yes, the state has already submitted the null pros.
Okay, thank you.
Okay, and is Ms. McLeod back?
We,
No.
if she's not, we can go back to position number 10 and 11, Vincent, Quantavious Vincent.
Okay, that was the one with anger management. Oh, Ms. McLeod is back. ACDC will be back in 1 second for us to do that case. Okay, so we've discovered, is Mr. Ty there?
Yes.
That there's no courses that are offered at low cost. If defendant takes the plea, I will not require the anger management course. However, he will have to do the 40 hours of community service. Does he wish to still take the plea today?
Yes, Your Honor.
All right. All right. Okay, sir, please raise your right hand. Do you swear and affirm testimony you give today be the truth to the best of your knowledge?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a guilty plea today?
No.
Did anyone promise you anything in exchange?
No.
And let me be clear. On case ending in 5293G at position 11, I will be converting that fine to community service as well. Does he wish to still take that plea, Mr. Tyler? Make that clear. So it'll be 40 hours for a position 10 and 30 for a position 11 for a total of 70. Does he wish to take the plea?
Yes, Your Honor.
Okay. You understand the requirements, sir, as for the case ending in 4940G, you cannot go back to the Pizza Hut on Piedmont Avenue, and you are going to have to take community, and you have to do 40 hours of community service. As for the case ending in 5329G, you would have to do 30 hours of community service in addition. So is there, do you understand those requirements?
Yes.
And do you wish to, do you understand that you're not gonna have any further court dates regarding these charges?
Yes,
And you understand you're giving up your right to trial by judge or jury?
yes,
All right, as to the charge of simple battery, how do you plead, Mr. Benton?
guilty,
And as to the charge of failing to use a crosswalk, obstruction, criminal trespass, and simple battery against an officer, how do you plead?
guilty, guilty,
All right, I accept your guilty plea. What we're gonna do for count 2, he's gonna do the 30 hours of community service. I'm gonna suspend the anger management. But the 40 hours he completes for, he's gonna do 70 hours total. Let's put it that way. All right?
Okay. And Your Honor, can we waive the probation fees?
you asked me.
I will wait 3 months of probation.
It is time served.
It is.
Still.
All right, is there anything additional from State of Defense?
Nothing further.
No, Your Honor.
You asked.
All right, best of luck to you, Mr. Benson. That concludes the case.
Time served.
Time served, yes.
All right, ACDC is not back, Ms. McLeod, so we can't do yours yet.
I do have another client, Your Honor.
Who was the other person?
Just a moment. I'll tell you his name. It's Taurus Thornton, Your Honor.
All right, is Thornton at courtroom 2 by any chance?
Your Honor, we just took
we took a plea for that one. That's correct. We took a plea for Ms.
Okay, this one.
Okay, sorry.
That's okay.
Was there in fact a conflict?
Right.
Well,
Yes, but that's okay. I represented him previously because it was a conflict. I wasn't showing as his lawyer on this one, but I previously represented him because it was.
Yeah, you two great attorneys on this one now.
Yes, no worries.
I don't know if it's no worries, but
yeah.
The public defender's office conflicted out from, we may have to take Mr. Thornton's plea again. I hate to do that, but if the public defender's office is conflicted, was there in fact a conflict, Ms. Mel?
There was a conflict in a previous case where I represented Mr. Thornton. So I don't know if the facts of this case are so different.
Right, that's what we need. It might be different enough that Ms. Melnick could have represented him, but is there a conflict as it pertains to that position?
Not on this case, Your Honor, it's only applied on a previous case, from my understanding.
Yes.
Okay, the facts might be, we're gonna go with it today. All right.
I think so.
We'll go back to you at ACDC in a moment, Ms. McLeod. Who do we have?
There's also another client that I have. I don't know if I have not been able to speak to him since this morning, but he is my client. That's Stanley Palmore.
Is Mr. Palmore at any place where Ms. McLeod could give them a call at this time? I don't think so, Ms. McLeod. Please hold for one.
That's okay, but it's I noticed it wasn't showing my name on the calendar, but I actually represent Mr. Palmore.
All right, and ACDC is back. So can we take that position? Was it Miss Bowden?
Yes, Your Honor.
It's Bowden.
All right, let's do Miss Bowden's case. If I can find it. Miss Bowden, your case is 23 CR 001291F, and you are charged with simple battery and theft by taking. Do you understand your rights?
Yes, ma'am.
All right. What's the announcement for this case, Ms. McLeod?
It's a negotiated plea, Your Honor, because based on what I have discussed with my client, it seems that she has already served all the time that the state is asking for her to serve. Is that the case, Ms. Falk?
Let me just double check, but I believe so. Yes.
Yes.
Let me double check the time.
I see they're asking for 60 days. How much time has she? It's not on the calendar how much she served.
That's because I don't think she served any time toward that. I think the time she's been in jail is on a new felony case.
She denies that. She says she's been arrested before on this particular case.
She has, but she didn't serve any time on the previous arrest. Hold
Did
on.
she get a signature bond or something? Miss Strong, can you look at it too for me to see how much time you see for this particular
Sure.
charge?
I think she was given a copy of charges. This was during COVID. But let me just double check. Because I think I looked at this one because I thought there was actually going to be some jail time accruing, but I don't think there was any because she was given a copy of charges. Let me just double check. No, okay, she wasn't given a copy of charges. How she was booked in, it looks like she was booked in on April 14th of 2021. And bonded out April 15th of 2021 on a $4,000 bond. So she served 2 days.
Okay. So she doesn't get credit for any more time than that?
No, because the time she's currently in jail right now is on felony charges and has nothing to do with this charge. So the jail's not going to give her credit for that time.
What kind of bond does she have on the felony charge?
She has a no bond. So she's not going anywhere, well, at least not right now. Let me see. She is on, I take that back. She's on a $17,500 surety bond on 24 PI 005400. That bond was set on the it looks like the 29th of July.
So in that
this
case,
case is not holding her at all.
Okay. You're saying that case is not holding her?
This case
is not holding her.
Her case on the calendar is not holding her at all. It's her felony case that's holding her up.
I see. Well, I need to talk to her just so she understands that you want her to serve 60 days because it wasn't clear. And I thought that was why it wasn't there. You understand?
No, I totally understand, but
yes.
Okay, so is there a way for Ms. McLeod to speak with her again?
They can do a breakout because I don't have access to a phone right now.
Breakout is fine for me.
Okay.
And Your Honor, I hate to be a pain while we're here. We might as well address it. On Taurus Thornton, I understand that PD Melnick said that there is, in fact, no conflict. However, I think there is. It looks like when I looked into the victim, it looks like the victim took a plea back in 2012 where she received an appointed attorney. The appointed attorney's name was Brooke Antonio. That's what it looks like based on this handwriting, and entered a plea. Since that's the same person who's the victim on our case, I don't think that's a conflict that just goes away.
Okay, so is it possible for us to recall Mr. Thornton at the jail and let Ms. McLeod speak to him briefly and reaffirm the plea? As well, I know that seems strange, but if we want,
I did speak to him this morning already, Your Honor. I spoke to him.
Okay,
Okay.
So we still need to call him back and just run through it very quickly, if possible.
On the case from 2012, was that a misdemeanor or a felony?
It was a felony pled down to a misdemeanor.
Okay.
And it was a crime of moral turpitude. So it could be technically, hypothetically used if it were to have gone to trial, it could be used. And so I don't think that conflict just disappeared.
I think I'm agreeing with you, Ms. Falk. I'm saying we have to recall it. So let's try to recall that one before we go today.
She's gone right now, though.
The client can waive conflict issues as well, so.
Okay.
Can, but did he is the question, and we don't know. So,
we can, instead of having Ms. McLeod talk to him, or we can see if he would waive any of those issues. And then if he does not, then we could have Ms.
Okay. That either way is fine, but don't we still have to have Mr. Thornton brought back to ask him that, or is somebody gonna walk up there now? Because what I don't want is him to remain in Fulton County Jail and he took a time served plea.
Completely understand that, Judge. where was he? He was on?
I don't remember where he was on the floor.
Well, Ms. McLeod is in the breakout room right now anyway, so you all have a minute.
Let me see, he's, Mr. Thornton with Tilgham or medical?
Oh, he was in.
He wasn't in medical. I don't think he was on the floor. We walked. Where was Mr. Thornton?
Are we talking about Mr. Thornton?
Yeah, where was he?
He was on 5 South.
Okay, we might need to go back to 5 South for a moment. We have an outstanding issue, but we can take who you have here. Who is this?
Okay. Well, we have position number 35 and 36, Mr. Pittman.
Okay, what is the announcement for Mr. Pittman?
Good morning, Judge.
Good morning. This is not Ms. McLeod's case, is it? No.
It's fine, Judge, and I'm not sure. We're waiving, we filed a waiver of appearance and arraignment, and I'm not sure why they.
Okay, so we don't need Mr. Pittman today.
That's
There's some
correct.
work to be done on his case, and I'm assuming we don't need to be heard on bond either.
No, you're right.
Okay, so Mr. Pittman, your attorneys have some more work to do on your case. They were asking that you not be brought today. Someone will give you a call or reach out to you to give you further updates regarding the development of your case, okay? All right, take care. Have a good day. If we could just briefly go back to Mr. Thornton just to see if he will waive or if Ms. McLeod needs to speak to him further, if possible.
Okay, while I'm down here on 4 South, can we do Mr. Ramos? I have him here too.
What was the announcement for me?
And he was also reset, and we explicitly said he was not needed for court, so.
Okay, let me tell Mr. Ramos what's going on. Mr. Ramos, your case.
Ramos. He's coming right now. And now
All right.
Mr. Cartwright, he's there, what is he, position number 17? He's in downtown Florida.
He's what? I'm sorry, I couldn't hear that.
Mr. Cartwright, position number 17. He's
Uh-huh.
downtown. He's downtown Florida.
Okay, understood. Thank you. Okay, so Mr. Ramos, your attorney has some additional work to do on your case, and it's gonna be reset. They asked that you not come today, but I just wanted to get you that explanation. Someone will be speaking with you to give you an update regarding the movement of your case, okay? All right, take care.
Okay, now I'm gonna go back up to 5 South and get Mr.
Thank you, I appreciate that.
And Your Honor, on position 17, Christopher Cartwright, where the jail just said he's downtown in court, is that going to be a reset to next week, to Thursday? How are we going to address that?
I just reset it for Tuesday.
Okay, I was just asking so I can make sure I got the reset date.
All right, let's just make sure, Mr. White, that is where you want that case reset, number 17?
Judge, I'm just checking with Ms. Atai. If it's time served, we would want it as soon as possible.
Yes, Your Honor, it is a time served offer, so
but it's
it
not
can
guilty.
be.
So reset, is it?
Just reset him next week. It's gonna be a not guilty anyway, unless you're planning on. Okay. Well,
Okay, reset Tuesday. Thank you, Ms. Strong. All right, we're back at ACDC. Ms. McLeod, the announcement.
Your Honor, this is going to be a not guilty plea.
Okay, so you're gonna enter a formal waiver?
Yes, I will file a formal waiver for arraignment and request that she be placed on the trial calendar.
All right, and are we, do you wish to be heard on bond?
I'm sorry?
Do you wish to be heard on bond this morning?
For her, my understanding was there is a bond in place for this case?
This case is not the case holding her, Your Honor. It's her felony
Right,
case.
okay, understood. All right, Ms. Bowden, your case is gonna be reset. Your attorney has some additional development and work to do. All right?
Yes, ma'am.
All right, take care. Have a good day.
Thank you, Judge.
Come on down.
Thank you, Judge.
All right.
Now, Your Honor, I also have Mr. Palmore. I don't know what happened with him. I had called earlier.
I think
He's over here at ACDC. I have to, once I get done, grab all the guys.
we're doing the ladies first, and then Mr. Palmore will be brought, and we'll do interpretation.
Okay, I haven't spoken to him yet, so I just wanted that to be done. Thank you.
There are quite a few interviews that have to take place at ACDC when the men are brought, so hopefully we can get to those soon. This is Ms. Daniels.
Yes, number 19.
Okay, and Ms. Daniels, what is the announcement for Ms. Daniels? Ms. Melnick, I think you said you spoke to, or was it Mr. Ty?
Oh. Your Honor, this, it's a negotiated plea. I think it's just a time served.
Okay. All right, Ms. Daniels, your case is 24 CR 003515C. You're charged with a charge, I will not sound, obstruction and possession and use of drug-related objects. Do you understand your rights today?
Yes.
All right, Ms. Falk.
Sorry, Your Honor, I had to send a message to Ms. McLeod about Ms. Bowden's case. What case is this?
Position 19.
Position 19, and it's a negotiated plea?
That's the
No, I see my recommendation. Yes, it is. All right. So the state's recommendation is time served, 138 days. She would receive credit for, I believe she was been in custody for 69 days. Just to kind of briefly go over the facts of this case. Ms. Daniels was in with DBHDD. It has returned to us. She was on June 5th, 2024. She had exposed herself. The officers then tried to take her into custody. She began pulling away from the officers and struggling, resisting arrest. She was placed under arrest and she had a silver crack pipe in her right hand. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
You still stipulate, Mr. Ty?
Yes, we stipulate.
And that was your understanding of the offer. Mr. Ty, that was your understanding of the offer? Time served?
Yes, Your Honor.
Okay. Ms. Daniels, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Guilty.
No, not yet. Do you promise to tell the whole truth today?
Yes, I did.
All right. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
Yeah.
Did anyone force you to take a plea today?
Yeah.
Did anyone promise you anything in exchange for taking the plea?
No.
And by taking a guilty plea, you understand that you're giving up your right to trial by judge or jury?
Yes.
And you understand that taking a guilty plea may affect other aspects of your life, such as employment. All right. As to the charges I previously listed, Ms. Daniels, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Falk, Mr. Ty?
Nothing from the state.
All right. Best of luck to you, Ms. Daniels. That concludes your case.
So am I going home today?
If you don't have any other holds, they'll begin processing you out, okay?
Today?
I don't know. I can't guarantee it'll be today, but they're going to start processing you out, okay?
Okay.
All right. Take care.
Where is Miss Bowden? Miss McLeod said she needs to speak with Miss Bowden again.
Oh, is she at ACDC still? Correct? Is Miss Bowden still there?
Yeah, she is. Bowden.
Can Miss McLeod be put in a breakout, I guess, and speak to her briefly? Is there anything we can do at courtroom 2 while that breakout is happening? Probably not.
Hold on.
Nobody here.
Okay. So we are still holding on several positions, including interpretation.
Yeah.
Can we put Ms. McLeod in a breakout with ACDC very briefly?
Still have a plea with position 25 Hall. He's on 4 North. I don't know if they're getting him by iPhone or whatever.
I think so. They're moving. I think so. We have a lot left. It's just who's here now.
I don't believe there's not going to be anybody else, correct? Yeah, there's not going to be anybody else to this courtroom. Is that correct? There won't be anybody else brought into the courtroom too.
So everybody else will be seen on the iPhone on the floors?
Correct.
Okay, that's fine. All right, we'll be on a very brief 2-minute hold. Dwight, you have a question?
I was gonna see if while we're waiting, if I could be put into a breakout with Mr. Sriracho and the interpreter.
Yeah, they have to go to that floor. She's at ACDC and has not been brought yet. She's bringing all the
Oh, I
general.
thought they said they had brought him. I misunderstood.
No, not yet. He's coming. He's
All
coming.
right, no worries.
Thank you.
Judge Williams, Ms. McLeod is back with her client.
I'm
Yeah.
trying to come back as well.
I just wasn't sure if you saw her on
I was
this.
trying to come back. I don't know what happened. Ms. McLeod, you have an announcement?
Yes, it's going to be a negotiated plea for Ms. Boniano.
Okay. Okay, and what will be the additional time she has to serve?
She is not serving any additional time, Your Honor. Just to be clear, the state is not conceding anything. We're just saying that she is going to remain in custody regardless on her felony case. And so we're fine with reducing it to time served 4 days, credit for time served 2 days. And the 2 days she served was from, I believe she was arrested on this on, let's see, her booking date was April 14th, 2021. And then she bonded out April 15th, 2021, which would be 2 days. So it's 4 days, credit for time served 2 days.
All right, understood. All right, Ms. Bowden, before I ask you the questions, Ms. Fault, will you put the entire recommendation onto the record?
Yes,
and
Your Honor.
give me a brief, very brief summation.
I will, Your Honor. So on count one, the simple battery, the state's recommendation is 12 months, serve 4 days, credit for time served 2 days. That's going to be from April 14th to April 15th of 2021. No further contact with Wisdom Smith, and 12-week anger management, 40 hours community service, no firearms. Count two is 12 months concurrent with count one. We are asking for $1,500 to the victim, Miss Wisdom Smith, and an anti-theft course. What occurred in this case is that the victim was awoken by her friend, Miss Bowden, and an unknown Black male who she believed was with Miss Bowden. She stated she had traveled down to Atlanta from Connecticut to dance at the clubs here in the area. And when she got into the room, she stated that she was attacked by Miss Bowden and this unknown male defendant. Her phones were then, she also stated her property was stolen. I believe she stated a black iPhone and pink bag with her clothing was taken by Miss Bowden, who also punched her in the face several times. And after they punched her, they took her bags, put them in the trunk, and then left.
I'm gonna sound to make sure Miss Wisdom Smith is not
Yes.
present. Miss Wisdom Smith, are you present? Wish to make a statement?
And I'm sorry, we have Wisdom South and not Wisdom Smith on our in our information.
Is Miss South present and wishes to make a statement? Okay, hearing none. Ms. McLeod, do you stipulate the factual basis, ID, and venue? And was that your understanding of the offer?
Yes, Your Honor.
All right, Ms. Bowden, I'm going to ask you some questions to make sure this is a voluntary plea, okay? Please raise your right hand. Do you swear and affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No,
Did anyone promise you anything in exchange for taking a plea?
no.
And you understand by taking the plea, you're giving up your right to trial by judge or by jury?
Yes, but I'm still
And
gonna
you're still gonna get what?
You still gonna be on probation?
Well, following your release, you would be on probation, correct? You understand that?
I don't.
Yes, Your Honor, we would ask that once she completes the requirements that a probation be non-reporting.
Well, yeah, that's fine, but she would still be on probation until it was completed. You understand that, Ms. Bowden?
I can't make payments to.
Ms. McLeod, you want to speak to her to see if it sounded like she may not want to do this?
I got you know, because I was trying to see if I.
Do you want to speak very quickly?
Yes.
All right, can we put them back in the breakout? It sounds like she doesn't want, we're not sure she wants to take the plea at this time.
She wanna put.
It's a need to talk. I'm confused. Again?
Yeah.
She's not going to take the plea. So I will waive arraignment for her.
Okay, so we're not taking this plea today.
That is
We'll
correct.
waive arraignment and reset further notice.
Yes, Your Honor.
All right, Ms. Bowden, best of luck to you, all right? All right, now we need to go back to Mrs. Thornton. Mrs. Thornton, we've become aware that potentially there was a conflict and the public defender's office was not or may not have been able to represent you in taking the plea. We're gonna put you in a very brief breakout with Ms. McLeod to make sure that you are waiving the conflict today or to see if there are other potential issues here. Okay, so can we put jail court iPhone in very brief with Ms. McLeod?
Just a moment, Your Honor. Could I hear from the state on the record what the offer is?
Oh, okay. We took a plea, but yes. Let's go ahead.
Yes.
Ms. Falk, will you put it onto the record?
Yes, Your Honor. The state's recommendation on position 42 is 12 months served, 44 days, credit for time served 4 days from May 23rd to May 26th of 2024. Balance probated, no further contact with Emerita Dixon. Stay away from 3107 Church Street in East Point. Position 43 was a battery family violence. The state's recommendation was 12 months served, 60 days. Credit for time served 16 days. That's from July 29th, 2024 until today. Balance probated, family violence intervention program, 40 hours of community service. No further contact with Emerita Dixon. Stay away from 3107 Church Street in East Point, no firearms. That's to run concurrent with the previous case. And on the theft by taking, it's time served 32 days, credit for time served 16 days.
Okay, I don't need to speak to him again because this is what we discussed when I spoke to him earlier. I just wanted to make sure nothing had changed.
All right.
Well, actually, something had changed. We reduced the 56 days on position 42 to 44
44,
days.
yes, I
was
heard that.
equal, yeah, so that it was equal with his subsequent case.
Right, so essentially nothing else had changed. So I had spoken with Mr. Thornton earlier.
All right, so Mr. Thornton, let's see. Do you waive the conflict that may have been present today when Ms. Melnick may have had a conflict? Ms. McLeod had discussed this matter with you, and we just want to make sure on the record, since Ms. Melnick assisted you this morning with taking that plea, that you're waiving that conflict, and you also had the opportunity to seek the advice of a conflict attorney. Is that all that true, Mr. Thornton?
Did you talk? Yes, I talked to her, but I talked the day yesterday. I never talked to Ms. McLeod. I talked to the lady in courtroom too.
That
who
is
my
true.
attorney is.
Right.
I never
Okay,
talked to him.
and she may have had a conflict. So do you waive that conflict and are you comfortable with Ms. Melnick representing you, or do you wish to speak briefly to Ms. McLeod to see if there are any concerns?
Oh, no, ma'am, I'm confident, listen.
You have to say you waive the conflict.
Yes,
You have to
ma'am,
say you waive the conflict.
I'm
Okay,
okay
so,
with it.
all right. We just wanted to make sure that the record is perfected. Thank you, Mr. Thornton.
Yeah, man, thank you.
All right.
Thank you.
All right, is that your only case, Ms. McLeod? Are you done?
No, I have one other, Mr.
ACDC, correct.
Palmore.
All right, we're gonna be on a brief hold while they get the gentleman at ACDC.
Yes, Your Honor.
Thank you.
Yeah, but you have to wait.
Apparently.
Oh.
What'd you say, Black? Medical malpractice. That's it.
All right, who is that jail court iPhone?
We have position number 29, Mr. Johnson.
Who represents Mr. Johnson? And you're muted at courtroom 2 if you're speaking, Mr. White.
I don't know. Your Honor, this is also, we waived appearance and arraignment for this, and
Okay, so Mr. Johnson, your case is not going to be addressed today. Your attorney will reach out and speak with you later. They've already reset your case for trial. Someone will speak with you before then to give you updates and further development, okay?
Yes, ma'am. Thank you.
All
Thank
right.
you.
Next, we have position number 25. Mr. Hall.
All right, and the announcement for Mr. Hall.
This is a negotiated plea, and everything, we don't have any issue with the actual negotiating, except for there seems to be some a discrepancy in the amount of time Mr. Hall has been incarcerated. We've got Mr. Hall says he's been in jail almost 100 days consecutively. So
On this charge?
well, it started with this charge and then back and forth between here and Union City.
Okay, can we confirm the amount of time, Ms. Falk? Are you able to see it?
I'm looking it up now, Your Honor. Let's see. I have that he was arrested July 18th of 2024. He's been in continuous custody since then, which I documented on the paperwork for him.
He's been in since June 3rd and has not been out since then.
Do we have any proof of that? Because the jail's going to need it. I mean,
I had to bring it with him.
okay.
He didn't have it yesterday when we spoke, but he said he had it in his cell. So.
See, I'm seeing he was arrested June 2nd. But then on June 3rd, he was given an SOB through the jail by Union City and was released. He was then rearrested for a failure to appear on July 18th.
He hasn't been on the street since the 2nd and 3rd. It's been back and forth between here and Union City.
Right. All I'm saying is the proof that I have shows he was released and then rearrested on July 18th. If you have anything that contradicts that, that would be helpful because I don't.
I have not specifically seen his proof of incarceration. He did say that he had it, and
Okay.
But he didn't have it with him when I spoke with him yesterday. I told him to bring it to court today, and he's holding up something now.
We can't, none of us can see that, so that's not extremely helpful. So, Ms. Strong, are you able to see anything different from what Ms. Falk sees? So your contention, Mr. White, is that it should be time served?
Actually, our calculation he still had some more time to do, Judge, but considerably less than what the state's asking.
So since he still has time to serve, Your Honor, I'd ask that this be reset to next week. That will give everyone a chance. I mean, we're asking for 210 days. So he's got more time to serve regardless. So we would ask for a 1 week reset just to get that documentation. So,
and I don't think that will result in any prejudice to Mr. Hall. Mr. Hall, we're going to reset you 1 week because there was additional time for you to serve anyway. And that will give us time for you to show your attorney that proof. So that
I got the proof right here, ma'am.
I understand, but no one can read that. And
we can have a deputy out there read it that way.
If he still has time to serve, Mr. White, and he wasn't getting out today, I don't think it's gonna Okay,
just 5 days.
by your calculation, Mr. White, how much additional time would he have to serve?
He told me he'd been in jail 100
I've been
days.
June the 4th.
Okay, don't say anything yet, Mr. Hall. Let me speak to Mr. White. Mr. White, go ahead.
But I think there was some issues. If it's what he told me yesterday, June 3rd or 4th, then I think there's another, that couple of weeks at least. I don't have a pen and paper in front of me to do math.
I'm terrible at math too. So if you're saying you believe it's another couple of weeks, a reset to Tuesday for Ms. Falk is not gonna prejudice Mr. Hall. All right, so we're gonna put him on next week's state all purpose with the explicit instructions that we need to have this calculated and Mr. Hall's proof reviewed at that time.
Mr. Hall.
Okay.
So what date is it going to be placed?
It says on here.
No, Mr. Hall, I'm not talking to you. Hold on. I'm asking.
It'll be 8/20, exactly
Okay.
1 week today.
Next Tuesday. Okay.
Next Tuesday.
Ms. Hall, I'm going to come see you Monday. When they come get you to bring you to the booth, bring that with you. Okay. So I can see
Yes,
it. All right.
All right, best of luck to you, Mr. Hall. We should have this all worked out by next week.
All right.
And one thing about it next week.
No, who's the one that wouldn't come out? We have position number 47, Mr. Watson. He's not coming out of his cell. He's not cooperating.
Okay, so, was it, what was the announcement? What would the announcement have been, Ms. Melnick?
I spoke with him yesterday and it was gonna be a plea. So could you, take the phone to his cell, please?
I'll try, but he wasn't cooperating when we just went there. He wouldn't even get out of bed.
Okay, well, it was concert. He was getting out today.
No, Your Honor, but,
Okay, so we're gonna reset 1 week. Was it more than a week that he was gonna have to? Let me see.
right. Let's see. Yes, Your Honor, but, and I had more, I think I texted Miss Falk about this a little bit, but.
You did. And, but yes, I mean, if you won't come out of the bed to the door of the cell, I'm not sure what the jail can't physically remove him.
I'm not asking that.
Oh,
Okay.
Well, if he wasn't gonna get out, today, how much additional time was he gonna have?
I think it was,
couple of weeks, Your Honor.
right.
All right, a 1 week reset won't work, won't prejudice him, so we're gonna reset him 1 week as well.
I have the paper, okay.
I do understand your position, Ms. Melnick, I do, but if he knows he has a plea to take and won't come.
All right, Your Honor. Okay, thank you.
Thank you for trying.
Okay. You guys, just the paperwork, I've already done it. Yeah, I spoke to him yesterday. Who's gonna take him next week?
You were the next Tuesday anyway.
I think I'm all right. We'll be back.
All right, are there other positions we can take? Are we still on hold? We're still waiting for ACDC too. Yeah.
Your Honor, there's a position on the calendar, White, if we have a minute to just, figure out.
Position 38, what was that one's gonna be transferred?
No, I don't think so.
Calendar says.
The state did request a transfer to the DA's office due to the amount of property damage. We are waiting for the DA's office to indicate whether they will accept the case or not.
Okay.
Your Honor, this case is a willful obstruction of law enforcement officers. I believe the case with the property damage was already dismissed in felony. I mean, position 48 is willful obstruction. There is no property damage, and I mean, he does need to appear today. His felony charges that were holding him were dismissed on July 31st, 13 days ago. The only thing holding him in jail is the bond on this willful obstruction charge, which is the only charge in this case.
Okay, so you're asking to be heard on bond on this case when he's brought?
Well, and he is entitled to a signature bond. This has been holding him for 13 days.
Okay, he's gonna be brought at some point?
He's at ACDC.
Okay, so when he comes up. All right. And remember, obstruction can't go signature bond through the jail anymore.
Well, even if it's through pretrial services.
All right, we'll explore that further. Thank you, Mrs.
It is a Riverside issue.
All right. Now, I know Mr. McLeod needs to speak with one gentleman, and the interpreter needs to help Mr. White interview one person as well.
Okay, so the Spanish interpreter is gonna be for Mr. Sriracha?
And what? And if we would just, I can just do it right here. Should probably just wait and just got a nice one.
Okay, so I guess what we have to do is put courtroom 2 in a breakout with ACDC. Unless there's another, I don't think there's another way.
You know what, I can try to test it out. I can have him just do another Zoom in the other room. We have another computer over there.
Okay.
So I'll try it that way.
We still have to use this computer here though, so I don't think that's gonna do anything for us. And this shouldn't.
No,
Oh.
as far as doing the other cases, I can continue on with the other cases and then still do the interpreter case next door.
But what I'm saying is I have to do it on the computer here in the courtroom, so.
Well, we could still do Ms. McLeod's case while you did that one. That would be one other case we could do, Mr. White. I understand what you're saying. You and Mr. Ty will be gone, but we could do Ms. McLeod. We're just trying to move us somewhat along, but if it's not going to be helpful.
Yeah, I understand. I mean, this shouldn't take long at all. He's got another hold that I'm gonna recommend he just waive his case to begin with, so.
Okay.
However you guys decide. I mean,
That's fine. We'll just let.
I just come to work and do what I'm told.
All right, let's go ahead and do that now. Instead of you trying to do another Zoom, let's just put courtroom 2 in with ACDC briefly, and hopefully we can release Ms. Chancey. Ms. Chancey, please raise your right hand. Do you swear and affirm that today you will make an accurate translation from English to Spanish, Spanish to English, to the best of your skills, knowledge, and ability?
Yes, Your Honor, I do.
All right, and please state your name for the record.
My name is Adriana Chancey.
All right, we're gonna go ahead into that breakout.
Thank you, Judge.
All right, are we ready? Mr. White, do you have an announcement?
¿Tiene un anuncio, señor Wright? You're muted, sir.
Muted.
Yes, Judge, we're just gonna enter a not guilty plea and I'll submit a waiver.
Sí, nosotros vamos a entrar a una declaración de inocente y una renuncia a la audiencia.
All right, so Mr. Sriracha, what's gonna happen is your attorney's gonna do some additional work while we set your case for trial.
Lo que va a pasar, señor Saracho, es que su abogado va a hacer más, va a continuar agregando trabajo en su caso para llevarlo a una sesión de juicio.
Someone will be in touch with you to speak with you further about how your case is developing.
Y alguien se contactará con usted para hacerle saber cómo su caso se va desarrollando.
All right, is there anything additional, Mr. White or Ms. Falk?
No,
¿Hay algo más? No, su señoría.
All right, Mr. White?
Señor White.
Nothing, Judge.
Nada más.
All right, best of luck to you, Mr. Sriracha. That concludes your proceeding today.
Gracias por,
Abogado,
señor
que me mande
Saracho.
rápido para mi
Muchas
país. Póngame un abogado que me mande rápido para mi país. ¿Para qué me quieren tener acá en este país? No quiero estar más acá.
I need an attorney that can send me back to my country. I don't want to be in this country anymore.
Okay, we can't discuss that today.
No podemos hablar de eso hoy.
All right, Ms. Chancey, will you sound to make sure no one else needs your assistance?
Yes, Your Honor. ¿Hay alguien más que necesite la interpretación en español para hablar con la señora jueza? Por favor, prenda su cámara o micrófono y avísenos.
All right, thank you, Ms. Chancey, for
Thank you. That's all right. Have a good day, Your Honor.
All right, bye-bye.
See you, Ms. Chancey.
You're welcome.
All right, and Ms. McLeod, I know still needs to speak with someone.
Yeah, she already did. It's gonna be.
Your Honor, I spoke with him and he's going to be taking a plea today, the negotiated plea.
Okay, thank you, Ms. McLeod.
What position is this?
Number 34, Palmore.
All right, this is Ms. McLeod's client. Mr. Palmore, your case is 24 CR 005325C. You're charged with theft by shoplifting and possession and use of drug-related objects. You understand your rights?
Yes.
All right. Ms. Falk, Ms. McLeod, you just said this is a negotiated plea?
It is, Your Honor.
All right.
And which case is this, Your Honor?
34 Palmore.
I apologize. I was asked, somebody at the jail is asking me to look at a case for SEA calendar.
That's
All right. The state's recommendation on position 34 is going to be 12 months served 30 days, credit for time served 15 days, I believe. Yes, from July 29th, 2024 to today. Balance probated, stay away from the Walmart. That's the Walmart located at 844 Cleveland Avenue in East Point. We're also requesting an anti-theft course, as well as 40 hours of community service. On count 2, which is the possession and use of drug-related objects, state is asking for just a time served plea, which is the 30 days served 15 days. The incident happened back on July 29th of 2024. Officers made contact with Jabari Williams, who stated that 2 Black males, this defendant and another male by the name of Gregory Gates, were shoplifting from the store. They took a total of $221 of merchandise, and as they were trying to leave the store, they also had surveillance video that shows both going from aisle to aisle, concealing merchandise and goods into their clothing, and then passing all points of exit. Mr. Williams did indicate he wished to press charges, which is why they were arrested. And on Mr. Palmore's person, a crack pipe was found related to drug paraphernalia. The state would ask the defense to stipulate to venue factual basis and identification for the purposes of the plea.
You so stipulate, Ms. McLeod, and was that your understanding of the
I'll stipulate, Your Honor.
And that was your understanding of the offer?
That is our understanding of the offer, Your
All right, Mr. Palmore, I'm going to place you under oath. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
And you understand by taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you further understand that you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you understand the requirements. You cannot go back to that Walmart. You're going to take a theft course and complete community service. But otherwise, you should not have additional time to serve in the Fulton County Jail.
Yes, ma'am.
All right, as the charges previously listed, how do you plead, Mr. Palmore?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Falk or Ms. McLeod?
Nothing from the state, Your Honor.
All right. Best of luck to you.
Nothing for the defense, Your Honor, except to ask if my client's probation could become reporting once he complies with the anti-theft class and the community service.
Yes, it can go non-reporting once he's done.
Thank you, Your Honor. And that
So that would be non-reporting or reporting?
Yeah. It'll go non-reporting once you finish the classes, okay?
All right, thank you.
All right, Ms. McLeod, if that concludes your business, you are free to go. Take care.
Thank you, Your Honor. Have a good day.
Thank you.
Number 7, Bella.
All right. Good afternoon, Mr. Bella. Your case is 24 CR 005309Y. In this case, you are charged with criminal trespass and damage to property. You understand your rights today?
Yes, Your Honor.
All right. And what is the announcement, Mr. Ty?
Your Honor, he's pleading not guilty and I'm gonna make a bond argument.
Okay, so we're gonna waive arraignment, reset his case for trial. Ms. Falk, I'm sorry, let's go to Ms. Tyson. Ms. Tyson, what is the defendant's history?
We have 52 arrest cycles beginning in 1991. His last arrest was December 16th, 2022 in Hateville for aggravated assault that resulted in a felony conviction, December 12th of 2023. He received a time served, it looks like a time served plea, no probation on that case. He has a misdemeanor conviction out of Fulton County for, aggravated assault that was amended to a battery, August 27th of 2019. He has another misdemeanor conviction out of Fulton County for simple assault. Disposition date on that case is September 27th of 2017. And that's all within the last 10 years. He does have another felony conviction. Out of Fulton County for aggravated assault. That's from December 20th of 2013. He has an additional 3 felony convictions outside the 10-year period. 1 for aggravated assault, criminal trespass, and cruelty to animals in 2006. He has another aggravated assault from 2011 and an additional aggravated assault from 2011. He has one violation of probation from 2000. Nothing to add, Your Honor.
Thank you. Ms. Falk?
Yes, Your Honor. Your Honor is actually the judge who issued him a $1,000 surety bond on July 31st of 2024, excuse me, with a no further contact from Melissa Cruz and a stay away order from 3363 Carriage Way. Just to refresh your recollection of the case, this happened July 29th, 2024. Melissa Cruz stated that the defendant had been drinking, decided to kick her bedroom door in, When he did this, she was inside of her room. He became angry because she wanted him out of the house. Officers then spoke to the defendant. The defendant stated that the Miss Cruz shouldn't be in the house and he wanted her to leave. He did admit to kicking in her bedroom door in attempts to get her items and leave the items and leave the house. Officers did observe the bedroom door with damage around the door handle and cracked wood on the door frame. And so that's what led to his arrest, both his confession and the corresponding visual evidence. As you have heard, this defendant has been convicted a number of times of aggravated assault, crimes of violence. He got 12 months to serve for an aggravated assault that was pled down to a family violence battery, most recently in August 27th of 2019. And then again for an aggravated assault where he got 1 year to serve on December 12th of 2023. If I had to hazard a guess, I believe that may have been the reason Your Honor agreed to a $1,000 surety bond. Based on the Ayala factors, I don't believe anything has changed that would result in a reduction of that bond, and we ask the bond to remain as set. We would like to sound from Miss Melissa Cruz if she is here today.
All right, is Miss Cruz present? Wishes to make a statement?
And we did speak with her on her. She did say she wouldn't be on Zoom, but she says that she confirmed the events of the report. She agreed with the plea offer as we had made it. And she stated she does need time to gather some money and move out, which I believe was the reason for the stay away from that location.
All right, thank you. Ms. Atai?
Your Honor, there's no victim in this case. The charge is criminal trespass and damage to property. So Ms. Cruz has nothing to do with it. This home belongs to his mother, Your Honor, Jerry Bella. I spoke with her and his father yesterday. The property is in her name. They stated that they allowed their son to live there in the spring because he became very ill. He does suffer from Crohn's disease and is disabled. They allowed him to stay there, but they state that right now they are evicting anybody who's left in the home. And they also told me that the house has damage all over because I guess before their son moved in, it had been, I guess people had been squatting in the home and they said it was a crack house. So I asked them about the damage to the door and the cost of that damage, and they said the entire house is damaged. What's changed since first appearance is that he's sat for 16 days for this criminal trespass and damage to property charge on a $1,000 bond. He cannot afford the bond. He does have Crohn's disease. I can't imagine the jail food is a proper diet for somebody who has Crohn's disease. He does deny the allegations as stated in the warrant. If part of the arrest was made because of damage to the home, I think the officers there could have seen that the home was damaged all over, according to the homeowner, his mother. I'm just asking, after he sat for 16 days in jail on this criminal trespass and damage to property charge for a signature bond, either through the jail or pretrial services, and nothing further.
All right, I will convert it to a signature bond with the same conditions. He can't go back to that location at level 3 through pretrial per judge.
Thank you, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Number 48, Mr. White.
All right, and this one is a bond as well, Mrs. Hyde?
Yes, yes, Your Honor.
Okay.
And I would argue that he is entitled to.
Don't argue yet. You already told me. Let's go in order. All right, Ms. Tyson, because I am trying to. We have been here for a minute. Let's try to move quick. Ms. Tyson, can I have Mr. White's history? Hold on, Mr. White. Your case is 24 CR 005480E. In this case, you are charged with obstruction. Do you understand, right?
Yes.
All right. You have a right to remain silent. You have a right to an attorney, and this proceeding is over the internet. I just want to make sure you're aware. Can I have the history, Ms. Tyson?
This is position 48, right?
Right.
Okay. Defendant is a multi-state offender. He has 7 cycles of the state of Georgia beginning in 2014. We have a felony conviction, well, not a felony conviction, but a felony case out of Chatham County for,
What I'm
let's
most
see,
interested in, Ms. Tyson, do you see other obstruction charges?
yes, for a willful obstruction of law enforcement officer
How many? do you-
interference. It's one count, so it's one count for that one.
Okay.
Give me 1 second, let me click through the rest of them. We have another felony willful obstruction from 2022,
Okay.
and that's 2 counts of that one in that case.
Okay.
He has 1 cycle out of Arizona. That wasn't an obstruction. He has 3 cycles out of North Carolina. See, 1 was a felony conviction for assault and assault on a government official. Let's see. He has 2 cycles out of California for obstruction, resisting executive officer.
Okay.
Let's see.
That's good. That's what I need to know. Thank you, Ms.
Okay,
Tyson. Ms.
you're
Paul?
welcome.
So short answer, Your Honor, a lot of obstruction charges. I will, and convictions, actually. So on this case, this incident happened July 7th of 2024. The defendant, and just to kind of give you the reason we are asking for this to be upgraded, the incident as it happened in total is at around 4 o'clock in the morning. The defendant had damaged the property of Lucinda Freeman and Rick White. The defendant is the son of Rick White, but does not live on the property. He threw rocks and broke the windows of their home. Additionally, he also was charged in this case with disorderly conduct and interference with government property. The interference with government property is because the officers were approached by Atlanta police officer Lucinda Freeman, who lives on the property at 2453 Cornett Way, and stated the defendant had shattered her Atlanta police vehicle window. He was also arrested for breaking another resident's window, and that cycles back to Mr. Rick White, his father, whose windows he also broke at that location. At that location. Additionally, he has a disorderly conduct, again, for the throwing rocks. He initially refused to be placed into custody and became very irate and struggled with the officers, which was the basis for the willful obstruction. I believe he also ran from the officer. I just need to look at that warrant just to make sure I'm correct on that.
What's the current bond, Ms. Falk? Do you know?
The current bond, Your Honor, and yes, he did run from the officers before being arrested. The current bond is a $3,000 surety bond. I believe that's in light of the fact the defendant is a multi-state offender, has willful obstruction and assault charges against officers in multiple states, not just in Georgia. I know the defense is going to try to argue that this is a Riverside issue. However, I do want to point that the defendant was arrested on July 7th, 2024 at 4 a.m. A warrant was then taken out for him July 9th, 2 days later at 3:26 a.m. So that is less than 48 hours later. If Your Honor looks at Capistani v. State, which is a Georgia Court of Appeals case, 289 Georgia Court of Appeals 47, that is a December 19th, 2007 case. In that case, the court held that where a magistrate issue warrant was arrest warrant was done within 48 hours of the arrest, 17-4-62, which is basically a distillation of Riverside, applies, and those individuals were validly held on an arrest warrant and were not entitled to a signature bond. So for those reasons, we ask that the defendant remain on that $3,000 surety bond. As far as the Ayala factors are concerned, we believe he is also a danger to the community. He is a multi-state offender, and we believe he is a flight risk. One of the charges in North Carolina was a fugitive from justice charge. We also have concerns about him reoffending based on his overall total history. That's all for the state. And we would like to sound from Mr. White if he is here, and the law enforcement officer whose window was broken. I believe her name is.
Your Honor, those charges have been dismissed
Okay.
by your office on July 31st.
Finish, please. I'm gonna let I'm gonna let you speak.
Thank
Please
you
finish.
so much. And we would also like to sound for Lucinda Freeman. As we have stated, we are asking the DA's office if they wish to handle this case. Although the case was dismissed by Judge Brandy Brooks on July 1st of 2024, the reason for the dismissal was because the officer was not able to attend the preliminary hearing. So the judge dismissed the case. As you well know, Judge Williams, the DA's office still has the absolute right to take up that case and indict it. And that's why the state reached out to the DA's office to see if they still wish to do so based on these offenses.
All right. Thank you, Ms. Paul. I'm not gonna sound for the victims because it is an obstruction, but I will let Ms. Attai proceed. Ms. Attai, please proceed.
Yes, Your Honor, and you know, if the case is going to be referred to the DA's office, that's fine. But right now he's being held on a misdemeanor, willful obstruction, and his bond is $3,000. And he has been, those felony charges were dismissed on July 31st. He's been held for 13 days. And I believe it is a Riverside issue. He's been held for 13 days without a hearing on the willful obstruction. I believe his felony attorney thought he would be released based on the order. Convicted felons, multi-state offenders, repeat offenders, they all have constitutional rights, Your Honor, and he's been held for 13 days on this charge. So I would ask for a signature bond through the jail. I believe, constitutional rights, federal law overrides SB 63. So I would ask for a signature bond through the jail on the willful obstruction.
And Your Honor, the willful obstruction was addressed on July 9th.
It was not. It was not. He's never had a hearing.
I'd be,
look at it in Odyssey.
I'd be more than happy to send the documents to Your Honor, and you can see it for yourself.
Let's see what we all have. Let's not shout. We are so close.
We can look at the case. If you look at the case in Odyssey, the only hearing.
Let's do that. I'm gonna do that now. Someone's gonna help me do that. Let's go look at the Odyssey to see if he's had a first appearance. Let's do that. And Ms. Strong, if you see anything as well, I would appreciate it.
I was just speaking with Mr. Jordan, who was stating that he's not holding on this case. It doesn't show anything on this case at all, which is
it's not holding.
No, he's not holding on this obstruction case.
So he already made.
It looks like it was a bind over, but in the system, I don't see anything in reference to this bind over, like no bond, nothing. All I see is the charge. Just give me.
And Your Honor, if I may direct you to 24 PI. Hold on. Actually, let me go back and double check something. Sorry.
Yeah.
Okay. We're gonna take a moment and look at this one. Is Mr. White the last person, or there's someone else we need to?
He's the last one, Judge.
Okay, so let's take a few moments and try to figure out.
And Ms. Falk, I see the 24 PI 004059 is the one that was dropped. Is that the one that you're referring to?
No, I'm actually referring to 004865.
Oh, okay.
Oh no.
I've got to take care of one thing while we look for this. 2-minute break, everyone.
Okay.
I want to see if they were the same charge as them. It's a different one. That's all that we just put on. Not in jail. Yeah, but he.
Hey, Ms. Hoda.
Yes.
Hey, Mr. Della, position number 7, he had a question about his stipulations.
Yeah, okay. Well, I guess. What's the question? You have to stay away from that address, which you would have to do anyway.
That's my only place to go. I have no other place to go. I don't. Now, I would ask that there be the stipulation of no further violent contact with her, because that's my only place to go I have. I haven't lived with my mother and father since 15 years old.
Well,
and I would.
I think they said they're evicting everyone out of that house anyway, so they want it empty, they're selling it. So that's
Yes.
why I didn't argue. And I think we ended up positively with you getting a signature bond to be able to get out, because the state was asking for 100 days from you. So I think that at least you won't be in jail.
Well, is it to living on the street?
I didn't
Okay.
argue for you to go back there because you can't go back anyway.
All right, I'm back. Did we come up with anything? You're muted. Oh,
It actually appears that PD Atai is correct. It looks like he was arrested on all of the 24 PI 004865 charges, except for the willful obstruction charge. So he has actually been in custody on the willful obstruction charge, it appears, without a hearing at this point. So he would be entitled to a signature bond through pretrial services on that.
all right, so defendant is gonna receive a $3,000 signature bond through pretrial services at level 2, with no further conditions. All right? All right, is there anything additional as it pertains to Mr. White? Mr. White, if you have a question, Mr. Ty is the best person to answer it for you.
Your Honor, signature bond through pretrial services,
Is necessary in light of the number of obstructions in his history.
okay, and sorry, level 2.
Level 2.
Okay, thank you.
All right. All right, yes, what's your question?
Ask, Deputy Francois, can you call me if, I know you don't have time either. but-
Is it a quick question about the bond, Mr. White? What is your question? Very
Yeah, behind, I just don't know does that mean I get out today, like signature?
If you
sign a
don't have
signature?
other holds, they'll start processing you out.
If I don't what?
If you don't have any other holds, they'll begin processing you out, okay?
Okay, yes, ma'am.
All right, best of luck to you, Mr. White. I know that there are some cases that were not, I didn't have announcements for and we did not address today. What happened when position 46? Oh, position 46 was released. I believe that's the entire calendar. Ms. Strong, will you review it for us?
We're completed here at ACDC. Thank you, Judge.
All right, thank you, Deputy Francois. Take care. Have a good day. Bye-bye. All right, I think this is the whole calendar. I hope it is. Ms. Strong, will you review for me, please?
Position number 1 was waived arraignment, reset jail jury. Position number 2 was a plea. Position number 3 was null pros. Position number 4 was a plea. Position number 5 was reset jail jury. 6 was null pros. 7, waived arraignment, reset jail jury with an amended bond of 1,000, pretrial level 3. Position number 8 was null pros. 9 was a plea. 10 was a plea. 11 was a plea. 12 was reset jail jury. 13 was a plea. 14 was null pros. 15 was release. 16 released. 17 reset for August the 20th SAP calendar. 18 was a plea. 19 was a plea. 20 plea. 21 wait,
21 is waived.
got it. 22 plea. 23 was null pros. 24 was a plea. 25 was reset for August the 20th SAP calendar. 26 was a plea. 27 was null pros. 28 was a plea. 29 was reset jail jury. Position number 30.
That transfer order was signed by Judge Morrow on July 18th of 2024. So it has been transferred to the DA's office.
Okay, so I have a question, and I'm sorry that I'm asking this right now, Judge, because I know you're ready to go. When y'all send these orders, I guess why are they being added to the calendar if they have received a order that was already signed? Because I'm asking because I'm the clerk today and I don't have it. So maybe I'm asking you the wrong question. Who are y'all sending these orders? Who are the orders being sent to for?
So the order was sent to the previous, so it was on a previous calendar long before it got set on this calendar. And that's who I sent the order to. Judge Morrow signed the order. It was then sent to the previous litigation manager who handled it on the previous calendar, as well as, I'm looking at it now, is actually sent to Judge Morrow and Miss Bridgewater.
Okay.
It was
Can you
signed,
send them to us? I'm sorry. I don't mean, Miss Paul.
Right.
Can you send them to the regular litigation managers if you don't mind, please?
Right, but she was the regular litigation manager when this happened.
They're
So
not.
that's what I'm saying. I can't see into the future. I can't send it to you.
No. I'm asking, can you either send them to myself, Miss Grace, Miss Lewis, or Miss Champion, or Mr. Jordan? Because we're not getting those orders, and I have the file here with no order.
Okay, and I did send it to Mr. Jordan back on July 18th,
Okay.
and I also sent it to you yesterday. Oh, sorry, I'm sorry. Actually, I sent it to you August 8th. Your name's on it. I can resend it if you want to see it.
I'll get, if you send it, okay, anyway, I have the file, but that's fine. If you could just send it to us, because if the other people get them, we're not getting them signed like they should. So we could just.
Right, and I hear what you're saying. I guess Ms. Strogum is just saying I did that. And so I don't know what else to do other than what I literally have already done.
I got it now. Thank you.
I've got a question. Should this, since this is now a felony case, should the state court case, should this be dismissed?
It should be, yes. It should have been closed when the order was signed and transferred, yeah.
Well, when will that happen? So we don't have to go through this again.
So because I never, like, when you CC, okay, we'll talk about it later. Anyway.
Yeah, because I just forwarded you the one I sent August 8th.
I got it, and I have it now, but if it's other people, if it's not directly like CC to me, I probably don't see it if it's not my calendar, but I got it.
If once the order is put in, that will close this one, so.
Right. Okay, so anyway, position number 31 was waived arraignment. 32 waived arraignment. 33 waived arraignment. 34 was a plea. 35 was waived arraignment. 36 was waived arraignment. 37 waived arraignment. 38 was reset. 39 was waived arraignment. 40 was a plea. 41.
41 is a waiver, and I've already, I've already emailed you a copy of the waiver of arraignment.
I saw it, Ms. Melnick, thank you. 42 and 43 were a plea. 44 was a plea. 45 was null pros. 46 was released. 47 was reset August 20th. 48 was an amended bond, 3,000 signature bond through pretrial level 2.
All right, any comments, changes, corrections, or questions or otherwise? Well, this has been fun. I haven't had the pleasure of doing SAP in a long time. It was fun to be with you all, and I'll be with you all again later in the month. Take care. Enjoy some fun. Oh, are there more questions at courtroom too?
No.
Okay,
No, I just think they're talking amongst themselves.
Bye-bye, everyone. Take care. Have a good afternoon. Yeah, everyone.